Hey guys, I had to remind myself like 10 times starting the stream not to say good morning because it is about to be noon here. Hey to everyone that's been hanging out. If you missed it, we did go over Doug Weinstein's motion to time limit the state's case in chief. Make them hurry it up, give them a deadline, don't let them go on and on for no reason. We read that this morning. I'll link it in the chat and the description of this video. But today is no jury in the court. It's just going to be the attorneys, the defendants, and we'll probably get some arguments. We'll probably get some updates on whether or not people did their homework. And I have a list. It's not exhaustive by any means, but some stuff that we might be going over today are Brian Steele's motion in limine regarding Bruton statements. Bruton rule means there's a bunch of co-defendants on trial. Well, if one of those co-defendants gave an interview with police, they made statements to police, and they said things during that interview that inculpate, that make a co-defendant look like they could be guilty. That co-defendant that their co-defendant made statements about probably won't have the right to confront their co-defendant as a witness, because typically a lot of people in criminal trials do not take the stand. So for Brian Steele, as far as Brian Steele is concerned, and the other co-defendants of Yak Gotti, Doug Weinstein's client, there are some things stated in Yak Gotti's interviews that inculpate several of the co-defendants, and Brian Steele has filed a motion to try to exclude those statements from that interview if it's played in front of the jury. So that's one thing. We have Doug Weinstein's motion to time limit the state, which I'm excited to see if Whitaker buys into that. She's been pretty dismissive and no to other motions, but maybe she'll be happy to grant this one in some way. In what way, I don't know, but I think she's personally interested in speeding up the case in chief that the state is slowly trying to present. So maybe we'll get that today. We also have to deal with Detective Dennis and the Operation Planters PowerPoint presentation. So maybe we'll see a little bit more on that. Remember, the state was supposed to go slide by slide, be prepared with, what they actually want to include in the final presentation when Detective Dennis gets back on the stand. And not sure that they will have that done, but we'll see. We also, in a similar fashion, need to deal with Max Shart filed a motion in limine last week relating to a social post that was posted by an account like SB with the on Instagram. And Love couldn't state in court how she knew when exactly it was posted or by who. After some squeezing and prodding last week, it took like 15 minutes. It was like a 15-minute argument. She finally said, yes, I can have Detective Sprinkle, Officer Sprinkle, come in and say, they hovered over the date on Instagram to verify the date it was actually posted. And, well, do you have that documented anywhere? Well, no, but Detective Gaither can come in and say that that's what they do. So we'll see if that happens today or if we get more clarification on that. That was one of the Instagram pictures where Bruce Harvey was like, who are these people commenting on the side? Who are these people with 70 likes? We could be going over a list of possible questions about the ex parte meeting as they might relate to coercion, a deal given, what Copeland understood. Because remember last week, we talked about this a lot. We clipped that segment out. Judge Whitaker suddenly doesn't want to allow the defense to have a certain scope that they expected they would have when they were able to finally cross-examine Kenneth Copeland. Judge Whitaker wants to limit it to, just maybe things that Hilton may have done in that ex parte, that the state may have done during that ex parte. Because remember, Love wasn't in there when Kenneth Copeland was. So they can't really ask Kenneth Copeland about Love's participation. And I see the judge's head. But she said, maybe if you give me a list of questions, we can consider it question by question.
This afternoon. Anybody know where the state is?
Anybody know where the state is? That's how we're starting. Stop it. Hit the like button, you guys.
You're going to be missing lots of lawyers.
The feed is quiet to me today. But hilarious start right there. Holy moly. Probably running to print out all 70-something of those PowerPoint pages that they were supposed to trim down. And if you guys missed it, the judge's first words were, "Does anybody know where the state is?" Oh boy. No jacket on Mr. Steele right now? And good to see everybody. Good to see everybody. Well, the judge is here, so they're not in an ex parte. They're probably in a something panic parte. KRM, that's right. KRM is here. We can get started now, Judge. Hey, to Flesh of the Gods, good to see you. Hey, Cash.
Invite them to come back to court.
Hey, Army Nurse. I think we have a different co-defendant. We have different masks today, so the germs must be hopping.
Thank you.
And don't forget, we also might hear some arguments about Doug Weinstein wants to suppress some of those statements. And remember last week, the state was like, we have a response against that. And Whitaker was like, well, I'd love to see it because from my understanding, what Weinstein's arguing is black letter law. Like, it's undisputed. We might see that today. I am looking forward to that. And thank you so much, FFS, for starting off these super chats. Can we take a pause really quick, like a comfort break? Look at our chat, nearly all green. Oh my god, you guys are green on the chat? Make sure if your names are green, you guys can use the Doug Weinstein emoji. There's some Kenneth Copeland ones. I can make some more if you guys... I should get a Brian Steele one in there and a Keith Adams one. Max Shard. Miss Westmoreland. I can make some more when we have some lulls in the court today. And then, love y'all, we're the next Rico. Yes, us unindicted co-conspirators here in the chat. And then Kevin G, thanks so much, says, did anyone check Glanville's chambers for the state? Oh, that's a good point. Oh, no. He's got another case to worry about. I can only hope not. Oh, that's funny. Thank you so much. And then Pierre Nesmith says, state, pardon our tardiness again. That desk is clean. Did they forget that there was court today? There is not a sign of life over there. Oh my gosh. For the table to be completely empty is a bit odd. Yeah. Oh boy. I don't really have words. I just have a, oh boy. The state quit. Yeah, we didn't know. Did they give up? They waved the white flag. I have a white towel emoji. They could throw it in if they're channel members. Thanks for becoming a member, Macamillion. You gotta use those emojis now. I did these crimes. I thought I made one of those. It was just a little bit tiny to read. Let me double check. I swear I made one. It's crazy that there were 2,000 of us here on time. The Law and Crime stream had like 3,000 people waiting when I pulled it up. And the state is nowhere to be found, but all of us were on time. Oh my god, you guys are funny. I see a ton. Thank you, Lady Bliss, for becoming a member. Yeah, I see a bunch of the buffering emojis in the chat. Yeah, the whole state is buffering. The towels. If you guys want, I'll make a love emoji. That way we don't have to use the salad emoji. The state is watching on live. Are they back? Well, but if they're back there with Whitaker, they should still have their stuff at the desk. Unless they don't even, like, no card of documents today. No folders. No case law. We're just gonna wing it. But yeah, see, like, you can kind of still see the corner of the desk. It's nice and empty. Nice and empty. Very clean. Yeah, I know Whitaker's in the courtroom, you guys. Yeah, 15 minutes late, case dismissed. I know Whitaker's at the bench, but somebody was asking if the state was standing up there. So my response was that it wouldn't make sense for the state to be in here, but not have any paperwork.
Here yet, and the fact that apparently none of the defendants have been fed lunch yet, we're going to break, let them quickly be fed, wait for the state to get here, and then get started. So we'll be in recess before accomplishing a single thing.
How is the state not here? Like, can you imagine? Okay, like, I get that we all have opinions one way or another about Judge Whitaker, but imagine being any judge and a defense attorney just filed a motion, and we can look at it again if you missed it this morning. Doug Weinstein said, Your Honor, let me just pull up the document. Let's look at it again. Do you guys want to look at it again? We can at least look at the title. The title is pretty self-explanatory. I'm just going to pull the title up. I think it's very timely considering what's happening as we speak. This is ridiculous. And what's crazy is there's supposed to be some arguments about whether or not you can have the jury convict someone on an overt act that's not actually charged in the indictment. So you would think that the state was preparing by maybe having John Floyd, their RICO expert, prepared to come in. Where are they? Did they think 12:30? Did they think 12:30? Because someone in the chat said they thought it started at 12:30. Maybe it was love in the chat. But anyway, this morning we had looked at this document. And let's look at this title. Let's look at this title. Let's look at that title, you guys. This was filed Saturday, so Judge Whitaker just got to look at it this weekend. Maybe she looked at it this morning. And then the state's not ready today. Nobody's at that desk. But motion to time limit state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentation of cumulative evidence. Could this be any more timely? Any more timely? Like, come on. Oh my goodness. Oh my goodness, you guys. They all called out sick. Like, I don't even have answers. Victor Mann, thanks for becoming a member. You're a member of us waiting in, like, what seems like purgatory for this trial to get a move on. Pierre Nesmith says, defense, this is another attempt on state to delay. But somehow Love is going to ask that Whitaker chastises both sides of the aisle. Like, somehow it's got to be the defense's fault, too. Oh, man. Oh, there was a message here. State is chasing the dog that ate their homework. Oh, what's Judge Glanville's dog's name? Is it Jasper? Well, I can't remember. Maybe they gave up. They all have COVID. Listen, I think if they all had COVID, they would happily say they can't come to court because they're all sick and that masks wouldn't be sufficient because it was all of them. I think they would have embraced having a note. Like, you know, when you get to go to school and you have a note for your absence, they would have embraced that, I think. This is just crazy. I was like, man, I'm gonna get some stuff done. We closed out the stream this morning after reading the documents. I'm like, 12, what am I gonna do with all this newfound free time? Arminos, thanks for the super chat. I rest my case. Yeah, maybe they're sleeping in. They're giving, I know Woody's not there today, but like Woody would say, maybe they just woke up feeling like they're gonna be a little late today. Oh, the dog's name is Jack. Why did I think Jasper? I'm combining Casper, our beloved Casper, and Jack into one name and got Jasper. But yeah, Arminus, listen. You sound like you have a serious and valuable career. What if you were just 30 minutes late and nobody knew you were going to be late? What if your whole team, what if you had a team and everybody was late and nobody knew that all of you were going to be late? And you had patients waiting, patients that are unfed, they haven't been fed yet, just waiting. Like, just crazy. I think Jasper does sound like a cute name for a dog. Yes, the state is late. I can toggle back over to, you know, look, we're just looking at what I think was a very reluctant recess by Judge Whitaker. She sounded exasperated when she said, I guess we'll take a recess before we've even gotten anything accomplished today. Yeah, I hope there's sanctions. I think they're going to say something about 12:30. I don't know why I'm thinking that, but I think they will. And if it was me, you guys, I would have been there at 9 because I thought they were starting at 8:45 until you guys told me 12. So... All right, was that a member of the state walking by the cameras? Oh, I wish it was showing the tables. I would love to watch them file into the courtroom right now. Rosemary Carter, thanks for becoming a member. Use those emojis to your heart's desire. Oh, FFS. I worked 17 and a half, nearly 18 hours yesterday, and I'm here on time. Where is the state? I don't know, but this looks like... That looks like Love's earring that was just standing in front of the camera. So maybe they're filing in now and thought it was 12:30. I can't wait to hear the apology, and I hope the camera catches it. But FFS says, late, I want to hear the reasoning. This is unjust vexation. Although I bet, do you guys think the defendants are happy to eat? They're probably bored sitting there all day. Either that, or maybe they planned... Does anybody in the chat have insight on how that works? So, if the defendants know that they have to be there, but it's only for a half day, but that half day includes like noontime, they obviously need to be transported earlier than that to get there by noon, so the court probably is obligated to provide the lunch for the day since, you know, they're going to be out of wherever they're being held from maybe like 11, 10, 9, 8 in the morning still. So I wonder why they might not have been able to just feed them at like 11:30. Maybe that just would have been too soon to feed them. Love the way I say button. Wait, are there different ways to say button? Oh my gosh, I'm gonna look up, like, you know those websites that tell you how to pronounce things in different dialects? I'm gonna look up all the ways to pronounce Bhutan. Button. Button. Yeah, that says, Love/Hilton, late? What'd that mean? Oh, I don't recall. Can you imagine they come in and they just like don't even acknowledge that they're late? I'm trying to look at the heads. We gotta identify people by the back of the head. Butt 10. Button. Button. See, this is nice. It's not like GIF and GIF. You can actually tell by the way you guys are phonetically spelling it that there's different ways here. Right? I think it was Love's head on the camera. At least one of them. Someone else went by that didn't look like Love's head, but the other one definitely did. And then Joel, thanks so much. The irony of Weinstein's motion to what is currently happening is perfectly timed. Yeah. Shout out to Doug in the chat. Either use the emoji or put a DW in the chat. Because it's crazy. They made him get that motion together last minute. Remember, Jay Apt was in the court like, look, he's busy. He's handling another case in another county. He's out of town dealing with that case, finally, because he's been caught up with this one. Your Honor, can he just have more time? And she's like, well, I want it by Friday still. And Jay Apt was like, well, we're going to do Saturday, sorry. So all of that had to happen. Jay Apt had to push. And I'm glad Jay Apt was there because I don't know if you guys think so, but Doug Weinstein's demeanor, he stands up on behalf of his client with passion. But when it comes to himself, he's very humble, he's very passive, he's very like Teflon, like lets things slide off, doesn't want to create chaos. So if it had been Doug Weinstein, I feel like he might have caved and not have really stood his ground that, look, I have other priorities right now for other clients and this client too. I need Saturday after all of this. So, but Jay Apt was there and said, look, it's going to be Saturday. Doug Weinstein gets this done Saturday. It's filed at midnight. Just for the state not to be here. Like, just crazy. Yeah, look at all the Doug Weinstein love. Doug sent them an email, court's postponed. All the Dougs. But yeah, he had to rush that in. And then the state isn't even here. Oh, we thought we see, okay, an Atkins head spotting. Terry just says goat. But it's just so crazy to think about. Thank you so much again, Joel. Emmanuel McCrae says, Woody's immunity is not as broad as represented. And Max Shark called this out last week, and I'm waiting to see if, and I think it's stupid that they have to do this, that it was even suggested they should do this, but to prepare the questions in advance. And I'd honestly, what I'd kind of like to see is before Whitaker, if she chooses to really make this happen, defense, if you're going to ask questions about things that might toe the line, I want to see the questions first. I think that's a weird suggestion considering she backtracked on what she told them they could do before they decided whether or not they wanted to strike all of his testimony or just go back to June 12th as the law says they should do. But this idea that, you know, we can't really question him about the scope of certain things when clearly people, you know, that are licensed attorneys in this courtroom still are unclear about his immunity deal. Well, can we question him about that? Can we question him about his interpretation of what he thought he was protected from at different points in time during his testimony? From June 7th to June 10th. From June 10th to when did he come back? What date was last Monday? The 12th? What did you have a different understanding on those days? What about August 13th when you realized Melnick wasn't there anymore? What was your understanding of things? If they have to turn these questions over to Judge Whitaker to get them approved, I hope she doesn't require that before the state finishes their direct examination and has a chance to try to preempt some of those questions. It just doesn't seem right. It just doesn't seem right. But yeah, I agree, Emmanuel. It's not as broad as it's represented, and if it was, the state could simply indict the leader and give the members immunity. But they didn't. They're protecting Woody, who seems to possibly have been part of it. Who knows? Cross will be interesting. My military mind says the state is sleeping eminently off a weekends of Grey Goose with Bonnie. Oh man. Can you imagine? I would have done nothing all weekend if I was the state except work. Nothing at all. Because I would be tired of being embarrassed in court for not being prepared. And hopefully I would care about my case. If I believe in what I'm bringing forward, I would care about it enough to want to put the information together. You know, sometimes when like yesterday I did a video like, hey, I want to look back at day 67, where we see Love kind of do something shady to misrepresent evidence, to make an argument, to force it in. 17-second video that they wasted 3.5 hours arguing about. And I was like, you know what? She was warned about, you know, having candor to the court, her duty of candor to the court in that same clip. So I want to make sure I tie in that clip where Whitaker is still warning her of the same thing today in August. And it's like, I think of those things in advance and have the clip ready to record with it. And that's just kind of a hobby thing, right? I think it's interesting information. I think it's worth connecting the dots. I'm not making these videos because someone's justice is on the line. like, come on. Like, care a little bit more. Care a little bit more. So hopefully they were not partying this weekend, but who knows if they were actually getting their work done. We're gonna find out. Danielle says, I found some case law that I think contradicts Love's argument regarding the overt act. I can email them to you. If they didn't, let's see, the mods may have dropped my email. And we're supposed to see the state present their case law where they say otherwise. I wouldn't be surprised if John Floyd shows back up to explain it. And I'd honestly be interested in seeing John Floyd explain it, because I don't think he's, you know, kind of BSing and just passing the time to get through this case. I feel like if John Floyd shows up, we might actually hear some interesting information and interesting arguments. So that might happen today, if anybody shows up at all. Maybe they thought today was Labor Day. Didn't you say something about a Monday? You know, the September Monday, we just thought that was today. Thank you so much, Danielle. And then Eva says, thank you for the comprehensive coverage. I listened to your content all weekend. Well, thank you so much. I appreciate the super chat for it. I'm glad you enjoyed it. And this is the thing, like, I'm doing it as a hobby. It's great to have met you guys through all of this. But then you think about the state, and not only should the state care about the case they're presenting, but they're on payroll to do this, or salary, or however each individual person is structured. They get paid to do this job. Why aren't they able to do this in a comprehensive and organized manner? I don't expect everything to be organized all the time. But when something's important, you've got a witness that you're having show up, when you've got to disclose to the defense what witness you're going to call next, and you don't have any of those three things organized and ready to go, there's always hiccups. How are you going to get justice for somebody like Donovan Thomas? What are you pursuing? It's not a good fight that they're putting up. So thank you so much, Eva. 84 Aries says they got held up at TSA. They're all coming back from the airport from their trip and got hung up at the TSA. Oh man, yeah, you can't play with TSA if you're on a time limit, if you got to show up somewhere on time. That is too funny. Thank you so much. Black Caesar says, at 11, you're hungry as hell in jail. They feed you breakfast at like 5 a.m. Okay, that makes sense. So I bet every day they're super eager for a 12 o'clock lunch. Especially when you're sitting there bored, you just start thinking about being hungry, needing to pee, all these things that if you were occupied, your brain wouldn't wander to. But thank you for the insight there. 5 a.m. is definitely crazy. That's a long time. I would definitely be hungry by like 9:30. FFS says, Your Honor, I'm mad, I'm hot. Steam has been coming off my bald head all morning. Where is the our state's babbling imbecile? I motion for a mistrial. I motion for a mistrial because I'm losing the last of my hair, says all the co-defendants that still have hair. The counsel that still have hair. Yeah, we need to get a Max Shard emoji, for sure. I think it's funny when a witness is identifying Keith Adams as the guy that's bald, and Max Shart will laugh. Because he's not the one being called bald. Yeah, this is a good point. There you go, Zion. Okay, I'm gonna make a Max Sharp one. We'll do the steam. We'll do some steam coming off the top of his head. I gotta figure out a way, because I like to make the face take up the whole little square. That way it's more visible on like mobile phones or whatever. We can find some way to have like steam coming off sideways or something. That's definitely gonna be the project. And then Satchel says, would Steele's motion trigger Whitaker to mistrial? Does he have a new motion, or do you mean the motion in, oh, you mean the, like, look at the indictment. There's like stuff in here that doesn't actually make sense. There's been a couple things he's been arguing, so maybe you're talking about this, hey, if something falls outside the statute of limitations, blah, 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 blah. I don't think that would lead to a mistrial, but it could lead to a judgment that could disregard a verdict returned by the jury if the only overt act they found is technically outside the statute of limitations. So, not technically a mistrial, but there is still a judge tool that a judge can use to set something like that aside, that particular verdict by the jury. So if that's what you're referencing, mistrial might not be the remedy. We would be all the way through the end of trial, but she could set that aside. And I wonder if she'd be inclined to. That'd be interesting. And then Zion, yes, thank you again. We're going to do this Max Shard emoji. Dublin Mug says, I'm convinced that YSL Grandma is actually Cat in the future still waiting to see this trial through. Oh, shout out to YSL Trish. That is very funny. That is very funny. She does do expressions, like when she'll look over and like that's something I would do. That is great. I love that. We should get a YSL Granny emoji. I gotta zoom in and get close on her face. There aren't really many, like, press photos are much more clear. I don't know if there's really any press photos that are like zoomed in with her in the frame. So it might be a little grainy granny, but that would be fun. That'd be a nice emoji to have. But me in the future, that's hilarious. Joel says, I'm like 99% positive at least half these jurors are already aware of all the drama behind Woody, Glanville, etc. I mean, these people are human, curious minds on a long delay, no doubt led to a Google search. Just saying. Man, one of my browsers, when I open to start a new page, is just a news ticker. And obviously at this point, you know, everything out here knows I'm interested in this trial, so it's going to be fed to me, right? My algorithms are curated for this content now. But even months and months and months ago, like a year ago, every once in a while, some bigger news would trickle into that news feed about this case or about Fulton County RICO stuff in general. So even if you're not trying to intentionally directly search for something, there's still so many ways that you're going to run into it. The memes or the court wardrobe, people posting pictures of Young Thug's fit today on the fan pages. Like, that stuff's going to be seen if you just exist in the regular world. You're not going to be able to just not encounter it. So I think you're right. I also think Doug's motion this morning readdressed that same point. He's raised it before, but juror misconduct. It's hard to sit and do nothing for 2 years to avoid looking at things happening to you in the real world. We've got the election coming up. If these jurors want to vote and they want to research the candidates, they want to look at, and I know this is kind of a stretch because there's a concept out there that people don't care as much about local elections. But let's say one of these 16 jurors or more does care about elections and local candidates. What if they go look up this Courtney Kramer candidate and they see, oh, she's platforming on the idea of ending the YSL RICO trial immediately. Why would she do that? Oh, she thinks there's not enough evidence. It shouldn't be brought. So how can someone exercise their right to vote and choose to be an informed voter and not run into some type of commentary about this case in Fulton County if these jurors decide to vote? And if I'm not mistaken, is like the jury summons can come through like a DMV ID card or is it through voter registration? It's through your ID card, right? I'll say if it's through voter registration, we know that at least all of them at some point have registered to vote. But I believe it's your change of address when you file, like, here's my new ID with this being my address in this area, and now you're on the list to be called possibly for jury. But yeah, like how are you gonna? Oh, we have some movement. 12:31. Maybe they thought 12:30 was the time, you guys. Thank you so much, Joel. Heidi Mosher, who had the state late on their bingo card this week? Me, late with homework, but not
Right, so I
late
think
physically. That's
that
crazy.
maybe the first things we need to tackle are whatever the evidence is going to be with our next few witnesses following Mr. Copeland.
Oh,
So I
Zachary,
know that,
Dennis, Sledge.
co-conspirator statements, as well as all the other evidence that y'all, the state, intend to introduce with the next several witnesses has been provided now in detail. So I would propose
Plus one
that
for the
that's where we
state.
start, unless somebody thinks something else would be more efficient. That work for everybody? Okay, so have y'all been able to get together on any of it to come to agreement on anything, or are we gonna litigate all of it?
Your Honor,
Yeah.
just for clarity, are we discussing the evidence that was shared by Mr. Atkins on Friday night? Is that?
I mean, I think there have been a couple of different shares. There was, I also don't, off the top of my head, know exactly when. There was one, and then there was the supplement, and then there's also, I think, something that Ms. Hilton shared that's in a spreadsheet, which I think covers the same things that Mr. Atkins provided already.
So I think there's multiple, God bless you, there's multiple things. We
Yeah.
sent the evidence regarding upcoming witnesses a few weeks ago, according to
Right.
Mr. Atkins. What we sent on Friday, Your Honor, was the co-conspirator statements, making sure that the ones that the state intends to use were provided. And then yesterday, what I did was I provided a spreadsheet of the co-conspirator statements that are found within Mr. Garlington's wiretap, which had already been provided, and Mr. Sumlin's wiretap that had already been provided.
Okay.
So I just specified which statements from those wiretaps we intended to use.
Okay, so that's a subset of the bigger set.
Yes,
So,
Your Honor.
I mean, we can start there if y'all want to start there. Or are those going to come in later in the trial?
Most of those are going to come in later in the
Okay,
trial,
well
Your
then we'll
Honor.
set those aside for now.
And we submitted the 31 through 60 witnesses.
Right.
Oh, I'm sorry. We submitted the 1 through 30 witnesses on August 8th,
Right.
2024.
Okay.
Judge, there was one matter with respect to the PowerPoint. I did send over the redacted one. And I spoke with, as I informed the court, I spoke with Mr. Williams about Mr. Ryan's statement and our intent to not use that.
Right.
So those two matters were off the table.
Okay, so yeah, we don't have to deal with a motion to suppress Mr. Ryan's statement because the state does not intend to use that. And I've also been informed that Mr. Kendricks is not going to be filing a motion to suppress the first hour and a half or 2 hours or whatever of his statement. So we don't have, that's also off of our to-do list.
Okay, that's 3 things accomplished.
Mr. Ryan, and what was received on Friday, I think, was our updated list of the people they actually intend on calling and co-conspirator statements, I believe. So we'll have Mr. Ryan's motions in limine, the basic ones of this is, inadmissible hearsay, those types of items based on what we just received. I don't know if those are the immediate upcoming witnesses. We're going to prepare it as fast as we can. We're just kind of, as you know, getting the rolling. This is what's actually being introduced.
And so we, in my speaking with Mr. Williams, I did let her know that if she had specific objections, there may be things that we could agree to. She did name some and I agreed with her. So we were continuing to discuss those. So if after those conversations, Ms. Abbasi and Mr. Williams feel like there's still more to litigate, that'll happen. But that conversation and that dialogue has started regarding those things that have been turned over to Mr. Ryan.
I think what probably would be the most productive is things that we have issues on, we make note of and make a record. This is the defense raises this issue, state agrees, so that they've been addressed and it doesn't, something got missed from the list or something like that. So we'll get with Ms. Love and do that.
That's fine.
We will
that's
get
fine.
that to the court as soon as possible. I don't know if they're in the next few witnesses category or not.
I mean, I don't either right offhand, but if it is, we're litigating that stuff this week.
Right. Could the state provide a little bit of guidance?
No, Your Honor, the stuff for the Jamari Holmes are not within the next 10 weeks.
Okay.
Oh,
Next
thank you.
weeks.
All right. That works.
Thank you.
How about Mr. Kendrick's statement that there's the Bruton issues on, right? And when's that going to get introduced?
So not in the next 4 weeks, actually, based on who it is that we intend to come before the witness that would
Okay,
introduce.
what witness will that be with?
Investigator Thorpe.
Well, y'all got him
Pearl
listed
Brand.
as witness number 5.
We do, but he has had, he will be moved down based on some circumstances that have occurred in his,
Okay.
he has some personal matters.
Okay, so is it still gonna be Burnett, Sledge, Zachary, Dean, Morton, Sprinkle, the phone custodians, Bernie, generally?
Generally, yes.
Okay, and then I guess Thorpe will be at the end of those now? Okay. And that PowerPoint, that's,
That's with Dennis.
that's with Dennis, okay. So he's several out. Okay. All right, so great. That'll give y'all some time to get together on that statement to sort Bruton issues. Mr. Steele, you also seemed to kind of be making a broad argument that nothing in his statement, in Mr. Kendrick's statement, even if it doesn't directly implicate your client standing alone, needs to be redacted, or there needs to be a limiting instruction about that. Do you have any law to back that up?
I'm trying to get proper law, but in this case, there has been over objection, the announcement that YSL is a criminal street gang that Mr. Williams, according to 3 supposed experts, is a member of, in addition to Trontavious Stevens, said that Mr. Williams is a member of, in addition to Mr. Walter Murphy, had Mr. Williams allegedly as a member of. There may be others. And then in Mr. Kendrick's statement to law enforcement on October 6th, 2015, he discusses YSL, the crew, the gang. So I think that under Bruton, it's an element of the offense of criminal street gang as well as RICO, that I believe that does not indirectly, but directly implicates Mr. Williams. But I'm looking for law on that, but that I do not want to waive that issue. In addition,
Well, yeah, just get me some law and we'll take it. Sounds like it's not quite as time sensitive as we thought it was, but we still need to get moving on it. So try to get me the law that would cover that.
in
It'd be
addition-
interesting if
I'm sorry.
Bruton
Go ahead.
No.
constrains
I'm done.
out overt act
that's
statements,
example.
co-conspirator statements.
Yes, I do want a limiting instruction, and that comes right out of the cases that I did cite. because that statement I cannot cross-examine. Mr. Adams cannot cross-examine Mr. Kendrick. That statement should be his alone. And it's confrontation clause, so it does not move the conspiracy forward. So it's not a recognized exception.
Okay.
So the second part of the question was, do you have law for the limiting instruction? And I already provided, but I could provide more.
Okay. And then I do want you to get with the state to try to come to an agreement as to what needs to get redacted to avoid Bruton, at least the classic Bruton issues, and we'll have to take up whether any kind of talk whatsoever about YSL gets included within that or not. But as to sort of the classic, you know, Mr. Williams did this, which I doubt if he says something like that anyway, but something that would directly implicate your client standing alone, y'all, the state ought to know what that would be and be able to redact that out. And it's going to be played as a video statement, right? So, right or no?
We intended to ask questions.
Okay.
Versus.
That's fine. That's fine.
And Your Honor,
Yeah.
I did that in my motion. I was specific and I give the timestamp where it starts. And I did it not only for Mr. Williams, but I did it for anybody else that I saw. And I did it for Shannon Stillwell. He's mentioned a great deal
Okay.
as well. So I believe that I flagged, if I missed anything, obviously, I'd like somebody to tell me, but I believe I've already done it. If the state agrees with it, then we need to figure out, make sure that the witness or witnesses know.
Sure.
But other than that, that's been done, Your Honor.
Okay. Thank you.
And Your Honor,
Yes.
while we're on this topic, just an additional issue. Not only are there Bruton matters, but there's also just typical evidentiary rule matters, such as speculation. At one point, Mr. Kendrick is asked who he thinks may have done this, for instance, and he names some names. That's the sort of thing that would need to come out, Bruton or not, if we're asking about speculation.
Okay, well, it sounds like it's not going to be played as sort of a running statement. It's going to be more targeted questions to the, I guess, investigator that conducted
Is
the
it?
interview.
Correct.
Okay,
So
so,
that would not even be an issue putting in.
So they're going to
trying
question
redact
first,
out.
then play the
Okay.
clip, not do this
All right,
long wholesale introduction.
all right, so
maybe.
let's turn to some of the specific then evidence that's going to be coming in with these next witnesses. So there's not anything controversial with regard to witness Burnett's evidence, right? And everybody else is silent, so I'm going to take that as a no for everybody else. All right, so Mr. Sledge, there are some co-conspirator statements from him. We already did his interview, right? Okay. Did we do his jail calls, or do we still need to do that? Maybe I can look at the more detailed exhibit list that y'all provided to everybody.
Well, that would have been a good idea.
Before we discuss the jail phone calls, I do have one possible issue. I'm not sure how the state plans on doing this. I see what is this? The fifth row down on Mr. Burnett, comparison photo infinity Q5 or Q50 and gas station still photograph. I don't know exactly what that means or how the state anticipates that presentation to go in court. I don't know what Mr. Burnett's qualifications would be to compare two photos. So I'm just wondering how the state anticipates that playing out in court.
Okay, So are you looking at the first 30 witness list? Is that what you're looking at?
I believe I'm looking at the same thing as you. It starts with 81 and then Copeland under the witness.
No, I think you've got a more detailed one than I do. I need to find the more detailed one. That was a Dropbox link, right?
Correct, Your Honor. And in regards to what Mr. Shard is addressing, Mr. Burnett, both back in, I forget the exact date, but during Deputy Sprinkle's investigation, he worked at an Infiniti dealership. He's worked for Infiniti for over 20 years. So it's lay opinion testimony. Obviously, the state has to lay the proper foundation when he's on the stand, but
Right.
his ability to recognize Infiniti vehicles is through his 20 years, and he personally has driven Infiniti cars. So obviously that has to come out, but it's not scientific expertise. It's just
He's
classic
an
lay
expert
opinion.
because he's got all kinds of daily experience with it from the last 20 years or
Yes, Your
whatever.
Honor.
Okay. So does that answer your question, Mr. Short?
It does. So I guess Mr. Atkins, you are going to ask him in front of the jury to compare the two photos and testify whether they're the same type of car. Is that
Correct, Mr. Shard.
okay?
As one piece of his testimony, I mean, essentially,
What's Steele gonna
Yeah.
say?
after the foundation is laid, he will use his lay opinion as a 20-year Infiniti rep to state his opinion of what specific vehicles are in both exhibits admitted and, demonstrative photos that are included in that Dropbox link.
I don't know, I would like the Honorable Court to look at the photographs. I don't know if we need a individual lay person to say that these are similar.
Do
So is-
I have, I mean, you, Mr. Atkins, are saying lay, but then you're describing something that I would think if this is beyond the ken of the average juror, it's expert, even if it's based on his 20 years as an Infiniti rep. So which is it?
So, Your Honor, he can be, his experience as an Infiniti rep, if he needs to be deemed an expert to state what the vehicle is in specific photographs, it's all through his training and experience of working with Infiniti's hands-on for 20 years.
Okay, well, that would probably then be expert, but do you want to show me what it is that y'all are, I mean, I see that one of the things listed is comparison photo, Infiniti Q50 and gas station still photograph. Is that what you want me to look at, Mr. Steele?
And Your Honor, some of these
Yeah.
exhibits, so there's the exhibit of the drive-by shooting that resulted in Mr. Thomas's death that is at nighttime.
Uh-huh.
And there's also a lit up, the Texaco gas station that's like 50 feet from the crime scene location. So that Infiniti vehicle, in the state's belief, is the same vehicle seen in the kind of more lit up gas station and also the vehicle that did the drive-by shooting. And so it is not as easy for just a juror to decide, because of the quality of this 2015 surveillance video, what kind of car that is driving down in
Okay.
either of these. And
So are you going to have Mr. Burnett look at the darker, more grainy drive-by and say, I can identify this as an Infiniti because of X, Y, and Z things?
Correct, Your Honor.
Okay. And then you're gonna have him look at the same thing in the gas station photo and say, in my opinion, this is the same Infiniti because of X, Y, and Z things?
He will speak about the make and model of the
Okay.
vehicle. He won't be able to definitively
is
say
a
that's
long
the
conversation
exact same
about-
car.
But
A
you
car
anticipate he'll
salesman.
be able to say, this is the same make and model as the one shown in here, and here's how I know that, here's how I'm able to determine that.
Correct, Your Honor.
Okay. I mean, that seems legitimate. And then obviously the jury will be instructed they can believe it or not believe it, but that seems okay. Okay. All right. So then we have Mr. Sledge and his jail call. Did we already do his jail call?
We haven't. I've listened to the jail call. I would object to the jail call. It's Mr. Sledge talking to his fiance or wife about what happened in court. And
Okay.
it's definitely
There's
not
a relevance objection.
it's not relevant. It's speculation. It's definitely not furthering any conspiracy. I'm not sure why that would be admissible.
Okay.
We would not play that jail call unless there was something that Mr. Sledge said on the stand that contradicts something that he said in the jail call.
Okay.
So, I mean,
So that's just potential impeachment. That's
Right.
not gonna come in during his,
right.
Okay.
Right.
all right, well, I mean, it's still out there as a impeachment if that becomes an issue. But we won't, yeah, it sounds like they agree. Okay, and is that it for Mr. Sledge? We already did his interview. So that's the only jail call.
Right.
Okay. All right, so then Mr. Zachary, and we've done both of his statements already. Jail calls and social media. Yes.
Is there an updated, can I ask the court to inquire whether there's an updated contact or address or both for Mr. Zachary? Somebody said that he's in North Carolina. I don't have any contact with that gentleman.
Okay, can you provide, if his contact information has changed since y'all last provided it to the defense, can y'all provide updated?
So the last time before last that we spoke with him, someone indicated that he was, but it appears that he is still in
The same
Same
place
location.
he was. Okay, all right.
The last week or just you to know if it matters to the court. Hold on, can I ask this question? We were told that he's very ill. That's what I was told from the detectives.
Okay,
And I was told that he's in a hospital. That was dated June 4th, 2024. So we haven't bothered him at all. But if that has changed, but I heard what the state said, it's
Okay.
information on the witness
We
list.
can discuss that aspect of him at the bench or something like that. I don't want to put personal information about anybody out.
no, I agree. Is that something we need to come up now and discuss?
We can.
Okay, let's do that.
All right, so we steamrolled through a few issues. Again, some of the stuff is delayed till it actually becomes relevant, but with Burnett, it sounds like maybe they're bringing Burnett in to say, hey, earlier in the trial when we were confused, is that a Pontiac grill? Is that an Infinity grill? We now have to call this witness to clarify so we can keep it straight. And we're going to let them come in as a layperson, so we don't need to have a Daubert hearing, get them, admitted as an expert witness. We'll just trust that 20 years working with the cars, they have enough knowledge. Now, on the flip side, I think if necessary, then the defense should be able to do the same thing if they want to bring in their own layperson witness that knows a certain type of car well for years and years of their life. So if that's necessary, I'm sure the defense will make moves to do just as much. Sledge is cleaned up. They said that they're not even going to go through the jail call because that would only come in if they need it for impeachment. They're not going to introduce it just willy-nilly. And then here they're looking at witness Zachary. They don't want to put his personal information on blast. Other than that, what I think is interesting is that Weinstein is okay with the first hour and a half of one of Yak Gotti's interviews just coming in. That solved a lot of problems that the state would have had to argue about. Or perhaps it was the other way around. Was it the state that said they didn't want to use it? Because I was a little confused why Doug would suddenly be okay with using it. So I'm not sure if I heard Love wrong or if she misspoke. But it seemed like, for whatever reason, the first hour and a half of Yak's statement is not being contested. So, And then let's see. King Divine says, remember the state doesn't have to listen to the judge. They get maybe 0 chances. Keyword maybe. Yeah, and I still can't believe we didn't get it addressed why there was lateness today. But maybe they really did think it was 12:30. Someone in the chat had said 12:30 in our other stream this morning, so it makes sense that all of them were late for that reason. Still sounds disorganized. But thank you so much for your super chat. Joel says, shout out to any of the YSL jurors in the chat. Shout out to you guys. Enjoying your day off, watching the same trial you finally get a break from. Julie Cat says, I can't believe one of these defense attorneys haven't swept you up for $100K a year. There's nothing Super Cat can't accomplish. Ugh. But see, when I read things for fun of my own free will, when I read motions on my own, I think it's different than having to find and research stuff. That is really sweet, and I appreciate the compliment. But it's so different having to do research that you might not be interested in the topic. So I have a lot of respect for people, like especially paralegal work, that do that nitty-gritty librarian type work to find everything, because it is really important. But it's not always as fun and interesting. You don't always get to find and read things with sassy commentary and little quips like Doug Weinstein's writing. Thank you so much, Julie. And then thank you so much, Julie Nickel, 2 Julies in a row for the super chat. FFS says, if I'm a juror, lock me up, $25 a day. This entire time I'd go in there and yell out everything I shouldn't even know from everything I looked up online. You'd be gone right away. You'd be like, all right, what's that, the little mouse from Cat Dog, the show Cat Dog, Winslow. Is his name Winslow? Where he like opens the door and then he turns right back around and leaves. That would be you. Thank you so much. And then Julie says, I can't believe you're not an attorney. You know so much about the law. Yeah, every time I don't know something, I like to like look at what it means, how it's been used, examples of it. So it's just something I've built up out of curiosity.
With regard to Mr.
Thank you so much.
Zachary, on the kind of detailed witness list that starts with Copeland at 81, all you have listed for him is the 2 interviews. On this other thing that we all got several weeks back that just kind of had the order of witnesses, you also had social media and jail calls. Is that something we need to sort through? Or do you not intend to use those anymore?
We tend to use them. We did provide the social media postings that he has.
Okay, that's in that other Dropbox, right? Okay, so let's go to that then and sort out whether there are any evidentiary issues with regard to all of the things you think you might use evidence-wise with Mr. Zachary.
On the 8th of August.
Yeah.
We put all this in there.
Whisper, whisper, whisper. Ty Wayne says, I've been in line waiting like a pair of retro Jays. Just hanging out, waiting for court to start. See, you were on
Zachary
time, unlike the
folder.
state. Thank you, Sheila, for becoming a new member. Garrett.
So we've got a group of social media, and then we have a couple of, well, I mean, we probably should just make sure while we're here in this folder that there's not going to be an issue about any of the rest of it either. But let's all Open up the social media folder first and voice any objections to any of what is in that folder so that I can take those up.
How much stuff is in this folder that they have to just wing it and look at? But Garrett, that's hilarious. Work for Yves Saint Laurent and you can be a YSL expert.
Everybody can see them, right? As long as we are looking at the same thing. Which if we're all looking at the same folder, we ought to be looking at the same thing. And like presumably everybody has already looked at all of this because y'all have had it for a couple of, week, 10 days, 2 weeks, something like that. So are there any objections to any of these social media postings and screenshots?
Just as a general objection, Your Honor, it's not a huge deal with this first photo, but the way we've been doing it is any non-testifying witness, if they've made comments on social media, and I'm not talking about the poster, but just other people, we've been redacting that. Again, it's not a huge deal in this case. Someone named No One Trusted says where you at, but
Right.
generally moving forward with all the social media, we're gonna ask that the state redact anything that's not said by a testifying witness.
All right, and I mean, if there is some reason why that's relevant, you can bring it up, but otherwise, I think that's a reasonable way to go about it. So that's how y'all will operate.
Yes.
Okay. All right, so beyond just that clarification, are there any issues with regard to the things in this folder? There are 23 different items in the folder. And like y'all ought to be ready to go with this. Because all week last week I said this is what we're going to be doing. So
I only
I
remember her
can't
saying
tell
that
whether
about one
y'all aren't
post.
saying anything because no, you don't have
One
any
post.
objections, or because you're furiously scrambling to look right now for the first time, which should not be the case.
I remember one
Okay.
post. And really that last post was in limbo because Love is supposed to have Sprinkle and Gaither say something.
It is.
She was talking to the defense there. Everybody protect Miss Niagara. They've got a YSL bag, YSL perfume. We don't want to see you become an unindicted co-conspirator or indicted. Yeah, more whisper, whisper. Accused Judge Glanville says, Adrian, stop at Publix on the way home and pick up some more ginger ale. You took the last one this morning. Canada Dry, not Schweppes. Do you guys have a brand loyalty for your ginger ale? McDonald's should do ginger ale and like crank up the carbonation in the ginger ale. That'd be pretty good. This is so good. Yeah, Team Canada Dry. I like that too. Eric says whatever's cheaper. You know, especially at Publix. What if the BOGO at Publix is Schweppes? Recused Judge Glanville.
Defense counsel, we're not going to be able to take this amount of time before every, sub piece of evidence, because we have, as y'all know, a lot to get through.
Heck yeah, I definitely love a good BOGO. This seems weird to me because she said it was turned over 10 days ago, but what was the drive that they turned over? That they just turned over? Because I feel like they didn't actually get this 10 days ago, as Whitaker's saying, but nobody corrected it either. Perfect. This is from a few minutes ago, but still applies. Cutthroat Radio just says, Whitaker just keeps helping the state. Recused Judge Glanville saying, my boo is wearing the earrings I got her with the heart. Yeah, that was her that we saw in the camera earlier, you guys. But whenever I was like, isn't that Love's earring that looks like her earring? We could tell. And then FFS says, I own an Infiniti QX60, so I can testify as an expert witness. They're letting them in as a layperson. This case would make my head look like Shard by now. Okay, and I gotta pronounce this right. Apunanwu? I need the phonetics in the chat so I can get it right. But thank you for the super chat. I'd be so mad as a juror in this case. Witnesses, attorneys, a judge just wasting our time being ill-prepared, lies, and foolishness. Day 114, you're absolutely right.
Our stance is a lot of these are just social media posts that do not touch upon any allegations. And we're just essentially most of these cumulative, irrelevance, 403. And so I know that Your Honor maybe didn't want to do it this way, but if we could maybe just put them on the screen and litigate.
This sounds fun. I want to do that.
I think that might be easier because there's several that are objected to.
Okay, so which ones are objected to, and we'll put those, we can all look at those.
Two,
that's 2015-57, that one? Is that what you mean? When you say two, you mean the second one in there, right?
the second one.
Okay,
Yes.
all right, and assuming the comments aren't there, this is for all of these, unless you tell me differently, this is a relevance and cumulative objection?
It's a relevance objection on this one in particular. From what I can see, it's a video. It's very dark, but I presume it's Lil D. I don't know that for a fact.
Okay, that's fine.
Yelling about Club Crucial and cussing.
And on some of this stuff is crazy, and they said cumulative and relevance, but I feel like it's still 403 because something like that could be prejudicial. You just show the jury social media posts of cursing, partying, That could make the jury think unfairly about the defendants in this case for nothing really associated with crimes.
If the objection is relevance. So if the
It's because
court
they
was
said
able
big
to
gun
hear,
slat.
what was being said, this was a public declaration by a YSL member on his social media page that it is Big Brucial. They're at Big Brucial, which is Club Crucial. The substitution of the C in crucial for the B is evidence of what our gang experts have testified to regarding what blood gang members typically tend to do. Mr. Zachary is referencing not only himself, but slime takeover at Big Brucial, YSL. They're using YSL jargon. It is evidence of the existence of the enterprise, the existence of the
So they're using blood
nature of the
language and
enterprise,
YSL
the
language in the
associations
same
within the
statement.
enterprise and the gang itself.
Okay.
Your Honor, we've beaten the dead horse of B's replacing C's a long time ago in this case. The state has played numerous videos of young men like 13, 14 years old hanging out in a parking lot saying B instead of C. And I mean, at some point, this is just,
Okay.
like, we've talked about this.
All right. So is the point of this that it is from Mr. Zachary himself and it is relevant to his credibility as to whether you tell me,
So
why is it not cumulative?
It's not cumulative, one, because no one, I think in here is going to concede or stipulate that YSL is a criminal street gang. So one, the associations that, and the substitutions that Mr. Zachary, who is an associate and a member of YSL, uses that tie himself and YSL to criminal street gang activity and criminal street gang customs is relevant in
Okay.
itself. Mr. Zachary is an associate and a member of YSL who is testifying. The fact, unless they're going to stipulate to these things, to the fact that YSL is an enterprise and that this is the nature of the of their behavior, of their actions, then none of this is cumulative when Mr. Zachary hasn't testified and the jury hasn't heard from this witness.
Okay. All right. I think that it is probative to show, on the issue of his credibility and what he may know about the gang, because I assume that there's, there might be some argument, oh, well, this is part of his plea deal and this is something that occurred prior to any of that, that arguably shows his connection. Now, if the next, 22 all do the same thing, then we'll have a cumulative issue. But this is the first thing from Mr. Zachary that's not, him sitting on the stand saying it. It shows. So
He
go ahead.
didn't enter a plea. He's not
Oh,
listed on the
okay.
indictment.
All right. All right. So I'm going to overrule those objections. What's the next item that y'all have?
Number three, relevance,
Okay.
and relevance.
Let me. What's the relevance?
Judge, in number three, I point out that Mr. Zachary's social media name is YSL_Lil D. He is in the picture with Shannon Stillwell. I believe that's Damikion Garlington in the back seat.
You
Mr.
believe?
Stillwell is throwing up the YSL sign. And what Mr. Zachary says in the post that is made on May 5th, 2015, all my dogs dirty, check for mains. I mean, I think it's self-explanatory, but the association, the nature of the,
I I'd ask the state to explain what they think that means, because
It's not self-explanatory to me.
Okay.
I mean, all my dogs dirty might be, but check for mains.
Well, that part.
Check for your man.
The check, like, check, what, all my dogs dirty, I mean, check for names, like names.
Come on, love.
Names, but
Come on,
all
love.
my dogs being dirty is a declaration by Mr. Zachary. And we would argue that it relates to him, his friends, his cohorts, YSL.
No, explain the
members.
next part, the part that she
Mr.
asked
Stillwell
about.
Seated next to him, Mr. Zachary, Mr. Garlington seated
Mhm.
behind him. It is an assertion of who they are and
Oh my gosh.
how he perceives them as a group. He is associating himself with them. He's saying they dirty.
Okay, well, so the check for mains part remains unexplained, but
I don't know why Mr. Zachary proclaiming all my dogs dirty would have anything to do with this case.
yeah, well, I mean, it might make something more probative more likely than it would be without. So I'm going to overrule that. It may or may not mean what she asserts it to mean too, but that's for y'all to argue. Okay, which one's next?
Number 5, relevance. And I'll just point out that we have already through 3 and 4 and 1 and 2 established that YSL Lil D is his handle at this
Okay.
point.
Yeah, so we don't need it for that anymore, but here we've got stack of money and a firearm.
I don't,
He said 5.
I'm sorry, 4. I'm sorry.
Okay, well, I'm looking at number 5. So let me get back to number 4.
That was a little crazy.
All right.
Love, explain this one part.
State.
Rambles on about something
All right,
else.
4's out. Is 5 next, or what's the next one?
I don't, unless someone else on the team or on the defense speaks up, I'm okay with 5.
Okay. So what's our next one we have objection to?
Number 6, there's no objection, assuming the proper redactions are made. Number 7, no objection. Number 8, irrelevant, and also, so 401 and 403.
All right, let's look at number 8.
Talk over the music, copyright strikes. Or show the defendants, they're probably bobbing their head. They're probably just throwing up signs in the video or something like that. It has to be body language.
All right, they're not going to use 8. I want y'all a little more ready to go tomorrow, okay? I feel like we're looking at them right now and making the determination, and that was supposed to be done before now.
When was it supposed to be
Number
done?
9, same objection. Well, relevance.
And this is moving quick if you ask me. It's not their fault they're objecting to every single one. And if the state's agreeing to keep stuff out,
Response.
they have valid grounds.
And also, to the extent y'all can get together and agree like you did for a couple of the statements, that would save court time as well.
Imagine she rushes them along and then moves on to something the state's supposed to have done, and then the state isn't ready to do that, and she's just like, okay, we'll just recess for the day. Like,
Okay, see, this is 3 already that y'all objected. They said, yep, okay, we won't use that. So if y'all get together, maybe we can do more of that. What's next?
Number relevance, 401 and 403.
So this, I think we may have, number one, we may have already put in the picture, but number two, it is, the association with not just Mr. Stillwell, here it is the witness in the elevator with Mr., or in the photograph rather with Mr. Williams. And I believe it was Oakland standing in front of them, and this was posted January 2nd, 2015, 8 days before the Donovan Thomas murder. And the caption is, at Woody, 372, at SB.
Oh, it's a little Woody post
_ living lovely, at Thugger 1, a heart, and.
where he's tagged.
Green snake emoji for the YSL, gang. So our argument is that this shows an association.
All right, I'm going to allow that over objection. And I've run the 403 analysis and overruled that. What's next?
This appears to be actually my client's post,
I don't know which number we're looking at.
11,
Hmm.
where I'm presuming, standing next to a gentleman that goes by Trouble, who I believe is deceased now and is, oh, okay, it's a different Trouble, I'm sorry. He is not deceased, but I don't know, his name has never come up in this case at all.
Okay.
So I don't know what the relevance of that would be.
Relevance.
Judge, we don't have to, introduce this photograph.
Okay.
So why are they trying to introduce it anyway? Why is it the defense's fault that they have to fight this? If the state is putting in random
Number 12,
videos or someone's
I'm
listening to
going
a song or something.
Acknowledge that it shows Mr. Kendricks in the photo, which if they're going to argue association, that's fine, but this association is being established through 12. So I don't object, but
Understood. If the next 5 do the same thing, it'll be different. All right, so
and number 13 is relevance 403 as well. All it's doing is showing Mr. Stillwell, Mr. Zachary, and Mr. Garlington in a photo together. And this has already been, association's already been established, I think in picture number 3, maybe.
So, Your Honor, understanding that the defense feels that one picture is sufficient to establish a photo, and at some point maybe past one is cumulative, but this particular picture has a caption on it, the date of it being 2/17/2015, from top to the pen to the grave, wherever life takes us. Y'all gonna forever be my little bros, at 30DD, at YSL little D. Y'all go and follow them, by the way. So, Your Honor, our argument would be that the caption itself is relevant and the date of the association.
I would think highly relevant. I'm gonna overrule the 401 and 403 objections.
So 4 total have been overruled.
What's next?
1 was
Number
sustained.
14
The rest
is,
were agreed upon one way or the other.
Is a post by YSL Buck. That individual, to my knowledge, has not come up in this case at all. So I'm,
All right.
oh, is that Buck?
Yes, it is. Okay.
Vocalize.
All right. So are you?
I don't know what the relevance is. Buck's not charged. He's not testifying. He was mentioned in a a incident from 2013. So I'm not certain what the relevance is of showing a picture of Buck or a video of Buck holding what appears to be a firearm.
Mm-hmm.
Real big bullets, bitch. We ain't play with her. Yeah, huh? That's like the boy Bills. What they doing? So that's like the boy Bills, my motherfucking big bro Snake.
If you hit play, the first person you see as they're talking about YSL, Big B, little bitch, is Quindarius Zachary. So that's further evidence with the gun. It's further evidence of the association and the nature of the enterprise and the nature of the association. One more.
Chloe Albert. This is good timing. What is my fave soft sit 88 up to today?
And also underneath at the bottom, you see the hashtag YSL real slime with the snake emoji. This is this outward display of aggression, this outward display of, firearms, we would argue go to proof of the nature of the enterprise, the nature of the association, the nature of the gang itself, and the nature of the activities within the gang.
All right.
Your Honor.
Yes.
I mean, we've been hearing that explanation for months now. That the nature we're talking about videos posted on the internet by someone who's not charged, that has in the video someone else who's not charged, who's cussing and pointing guns, and
You should give the defense one win here, just because there's going to be 10 more examples of this.
That at this point, any probative value derived from playing this video at this point in this trial, after all the other videos that have been played, is marginal at best, and it's outweighed by confusion of the issues, prejudicial effect, and the like. I mean, it's just overkill, and all these videos, I'm not going to say all of them, but a great number of these videos have absolutely nothing to do with the issues involved in this case. And this is why this case is taking so long.
Well, I mean, I think it is probative of the assertion that YSL is a gang willing to commit criminal acts.
This is because Whitaker has no
Yeah.
conceptualization that teens
How
do stupid
many-
things,
So this is
young adults do stupid
Zachary,
things on social media.
Buck, and who was the other? Who was the third person?
So in her
we
brain, it's
know?
reasonable to assume it's nefarious all the time.
Not off the top
Corny.
of my
Okay.
head. Your Honor, but
Yes.
I wanted-
Buck
Nefarious?
is
Who knows?
asserted to be an unindicted co-conspirator.
Yes, and to be clear, Buck has not only has his name come up multiple times, he has been in video. He is his voice was played over a jail call. He recorded one of the videos with Trontavious Stevens and Mr. Williams. So yes, these two are YSL associates members. And also, just as to the point that Mr. Sharp made about the number of videos, the constant cross-examination and sort of rebuttal against this idea that it shows an association and the nature of the gang is that it's promotional, it's music, it's art, it's something that's not related to criminal street gang activity. So our position on that is unless there's this stipulation regarding that, which we assert that it's relevant to prove, that every time that they argue that a particular video is promotional or it shouldn't be taken literally, they are creating the need for the state to show the jury evidence otherwise.
Okay. Do we have a video similar to this one in already?
No.
Do we want to dispute that and point me to what is?
When you say similar, I mean, the state played.
I mean,
think
not like a music video,
the
but
state the state played, I believe twice they actually played it. About 13-minute video of young men talking about YSL and slime in a parking lot outside apartments.
Are they pointing guns at the camera while threatening to do things in the name of YSL?
I'm being told that guns were pointed in that video.
And is it I don't mean a music
No,
video.
it's not a music video. It's a video of,
And who are the people?
it was Walter, it was Trontavia Stevens, Lil D, Mr. Williams, Walter Murphy.
But not Buck or Zachary?
Lil D, what was that? Okay, so Zachary, I'm being told, was in it. Buck was not in it. I don't know what is important about Buck,
All
quite
right.
honestly.
If y'all want to tell me exactly what, exhibit number that is, or give me that to look at, but my inclination is that this sounds different enough and not cumulative. So I can look at it and, I may change my mind, but at this point, I'm overruling the 401 and 403 objections.
We'll get you that exhibit
Okay.
number. 15 is my client's undated Instagram post showing a picture of Mr. Zachary. I believe that's Mr. Zachary, although it doesn't quite look like him. I believe that's him. And he's standing next to a platter of pastries.
So I think that's a relevant subjection.
And cumulative, because the association
Foundation.
Okay,
it's
what does the
undated.
state say about that?
Judge, we don't have to use this initially. We believe that it could,
Initially.
rebut a particular line of cross-examination, but right now we won't use it in our direct of Mr. Zachary.
Okay, so there may be some cross-examination about whether they went to a bakery one day, and
No,
then this might be relevant. Otherwise, they're not going to use it.
And Your Honor, let me
I'm kidding. I mean, it may be relevant to something else, but who knows? I don't know.
So it's Mr. Stillwell's post
Right.
of Mr. Zachary, and his commentary about Mr. Zachary is what we were looking at that was
All right.
most relevant.
He's commenting my dripping. So he's commenting on his clothes.
Dripping in blood. There's a red jacket that he has on, and that jacket, our argument is that
Well,
that's what he is referring to.
Okay, well, at this point in time, we're not going to be using that one.
okay.
What's next?
16 is fine, no objection.
Okay.
Yes. 17 is fine, no objection. 18, 401, 403, the association with my client has already been shown. Not sure, Your Honor, just so you know, that is Mr. Zachary and Mr. Stillwell seated behind a bottle of liquor with large amount of
Robert
cash
says the
on it.
court reporter's dripping. Heck yeah.
So,
Shout out to the court
Judge,
reporter.
This is, part of our indictment talks about the purpose, and hang on, I'm going to just read the language. Obtaining money, as associates of Young Slime Life, the defendants conspired to associate together for the purpose with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity, including robbery, theft, and the unlawful sale of and distribution of drugs. This is Mr. Zachary posting large sums of money with Mr. Stillwell and asserting their unity. One thing about my brew, again, the B replacing the C, we all eating. So he's talking about,
Yeah, we're rolling in the dough. We're doing well. Do we have other things that already show this that are similar?
when you say similar,
No, I don't actually think there was a cumulative argument on this one. It was relevance and 403. Overruled. What's next?
Number 19.
Thank you, Red Hat Maverick. Let's start a super member wave. And then Sentinel gifted 5 memberships. Make sure you guys say thank you. Shout out to Sentinel in the chat. Use those member emojis.
And who all do we
And the
have
buffer emoji. The
depicted
buffer
in this
emoji's free.
photograph?
we believe that this is Mr. Zachary, Mr. Nichols, and the third person we're not certain about.
All right, this is showing Zachary and Nichols in the same kind of YSL posts with guns.
Showing, yes.
Okay.
Your Honor, 403.
So,
Highly prejudicial, outweighs the probative value.
it does not. Overruled. What's next?
I believe that's Mr. Zachary and Mr. Garlington.
Okay.
That is who is shown in this photograph.
Okay.
Number 22 is Zachary and Garlington. I don't have an objection.
Okay.
23 is another picture of Mr. Zachary and my client, Mr. Stillwell, at some sort of arcade, sticking up their middle fingers. I would object to that. Relevance 403.
All right.
Cumulative.
Days,
Go ahead. What's the state's response?
6 days after the murder of Donovan Thomas, this post is made. We gangster in every city we go.
All right, and this is 23, right?
25th. Oh,
20, which
yes,
one is
number
this?
23.
20, yeah, okay, right. Well, I just clicked out of it.
Belle Louise says, it's my
And the
day
main
off.
objection is
Lots of popcorn needed for this.
403 on this one.
And relevance. And Your Honor, while we're at it, the state said, brought up the caption. I don't know why that caption would be displayed. That's the words of Lil D. Sure, he's testifying. I guess potentially that could be impeachment, but I don't know why his out of court social media declaration would automatically be admissible.
It is the assertion, the public assertion, the fact that it is made publicly to display their dominance. This is 6 days again after Donovan Thomas. We believe that they went out of town into another city following the murder of Donovan Thomas, and an assertion that we are gangster in every city that we go. The fact that you made the post, that you put yourself out there with another YSL member in itself is evidence beyond the words that are spoken.
What rule of evidence would allow an out-of-court declaration by someone who's not is not a statement of a defendant or a statement of a party opponent. I don't know what rule of evidence they keep saying because he's saying they're gangsters.
I
Okay, but
assume, is he alleged to be an unindicted co-conspirator? I would think that would be the rule of evidence.
I don't know how this would be deemed in furtherance of a conspiracy.
Because it shows, number one, it asserts their dominance. It shows, it asserts their cohesiveness. We are gangster in every city we go. It promotes their, pull up the indictment.
I don't know. I know people that
preserves
travel out of town and they act like they own the
enhances and
city when they go there
protects their
too.
reputation, power, and territory by the posting of messages, images, videos, and songs demonstrating allegiance to the enterprise and a willingness to engage in violence on its behalf. It is literally a line that I just read is literally a line from the indictment. And so this post itself is proof of that assertion and allegation in our indictment.
All right, I'm gonna hold my ruling on that and we'll see what else we've got.
And Your Honor,
Yes.
for all of these that we're going through, there has to be some sort of foundation. I mean, if Mr. Zachary says, yes, I posted something like that, then that would be bolstering, right? It would just, or cumulative. If he says, yeah, I posted that, and this is the reason why, just because it's in the indictment does not make that assertion credible. So the witness has to testify to all this before it just comes in as an exhibit. Am I wrong?
Well,
I mean,
it has
that's
to
what
be
I will be
introduced
objecting.
in some form or fashion.
It has to be introduced. That part we agree, but not that it's not permissible or admissible as an item of evidence just because he says I did post it.
Right. Okay, so I'll withhold ruling on that one. What's next?
That's all the social media in
Okay.
this folder.
All right, so
Oh, yes. What's the exhibit number? And Your Honor,
yes.
the exhibit number for that other video that's already been played states 16. Oh, I'm sorry, 60 WA.
Okay. If y'all have it handy and can just shoot it to Ms. Pursfield and I don't have to go through the former court reporter to find it, that would be great.
And then recused Judge Glanville says, on a serious note, why bring Thorpe back to waste
If
time?
not, I'll
I think
try
they
the
mean
other way.
Dennis. No need for Woody.
All
He
right,
said he's lying.
so
Only reason is to get the
let's look
PowerPoint
and
in. But I
see
think
what
Dennis is the
else
one that's
in
coming
the
back to bring the
folder for
PowerPoint in.
Mr.
For what
Zachary.
reason?
There's, well, y'all can see the same things that I can see. Is there any objection to the other 5 items? I think one of them's, the last one's one of the interviews. So is there any objection to the other 4 items?
The second to the last one,
Yeah, I couldn't open that one.
I couldn't
actually.
either.
So can y'all maybe share that one? Do y'all know the one we're talking about? I don't know. It may be. It's 3.95 gigabytes, so maybe. It just seems to be in a format that,
How long? Is this a video? That's
okay, so it's the other interview. Okay,
That's a big
fine.
file.
All right,
Oh, okay.
So then objection to the other 3 items.
I thought it was going to be like a short video clip on Instagram, not an interview. I was like, 3 gigabytes, almost 4. And then Chloe says, what part of you can't be a dual
Anybody?
gang member doesn't love understand? It's like she thinks they are YouTube channels and you just hit subscribe and you can watch
Items.
all of
Okay,
them.
and you're
No big deal,
speaking,
right?
I guess everybody else's silence is assent here. Okay. All right, so that's Mr. Zachary. Should we look at, is Mr. Sledge, let's look at Mr. Sledge. He's going to be either right before or right after Mr. Zachary. Okay, let's see what's in his folder. All right, we've got a jail call folder, a social media folder, a tattoos folder, and then some other items. Have we already dealt with any jail calls for him?
Your Honor, that's the one that the state said they would only play for impeachment.
Okay. And that's the only thing in that, yeah, okay. So that's all right. And then how about social media? Do we need to go through his social media, I would suspect?
Yes, Your Honor.
Okay.
And Garrett says, Ural wouldn't let Max speak, but I almost said Whitmore. Whitaker does, but bias remains. Yeah, and I think it's strategic. I think, a lot of the stuff that references or involves Shannon Stillwell, it's Max's
Yes.
argument to make, but I think the defense is letting him carry more arguments because
Yes.
Whitaker seems amenable to him, to his suggestions. Thank you so much, Garrett.
If anybody else needs to use the restroom, all right, let's take a quick convenience break.
Comfort break, you guys. FFS says, the juror questionnaire they send you at 18, I've thrown away for years. Never once filed it out. The statement, it says, could be held in contempt if not returned. It's all lies. Well, maybe they know that you're doing them a favor because you would just do the Winslow walk in and walk out. I think when I've been called for jury duty, once was when I first went to college, like 5.5, 6 hours away. And I called and I was like, I live really far away. I don't know if I could just show up in 2 days. And they didn't call me anyway. Same thing when I moved to Florida and had gotten called. I called in and they just didn't want me. They do not want me sitting on a jury. I would do it, but they don't want me. But good info there. You've thrown it out and they didn't seem to care at all. And then Leah's dad says, I have never prayed for a downfall more than now. I'm glad this is being streamed for no other reason than for it to be public record. How dirty they are moving, and I hope it follows them forever. And, systematically, right? Even cases that don't go to trial, which, that's not televised either. Prosecutors can do some shady things to get a plea deal out of somebody. Tell them that they have evidence that they don't actually have. So the person's like, oh gosh, I'll never survive in front of a jury because they're saying, someone's going to say I did this. There's video of me doing that. But then maybe that stuff doesn't exist. But it doesn't matter if the person was made to fear without actual basis to the point where they decided to take a plea. So now they're convicted through their plea. And that's not televised. So there's still so much dirty, dirty stuff that is not captured on YouTube with people paying attention, opening their eyes. But great, great point. It's still a step in the right direction towards transparency. Thank you so much. Bama Rose, thanks for the $4.99. Garrett S. says, she's blaming defense for being slow so she can rule against Doug's motion and assign blame. This is a good point. She's repeated. I was like, why is she so hard on the defense today for being slow and unprepared? And what were some of the other terms? Do I have that open still? Prosecutorial unpreparedness. But we've heard Whitaker twice, 3 times, 4 times say the defense was unprepared. Inefficiency, undue delay, waste of time, needless presentation of cumulative evidence, which, that's not really relevant to the defense here. But yeah, I think you're making a good point that Whitaker has these phrases on her mind and is trying to point the focus, laser light, over to the defense doing these same things that Doug Weinstein's motion is saying the state is doing. So we'll see. Can't wait to see this addressed now in light of how we're moving along today. Great, great, great observation there, Garrett. And before I forget, let me go back here because who knows how long this comfort break is. Bama Rose says, I don't think she realizes that no one on the defense wants to talk to the state without being in court and on the record. And why would somebody? I mean, look at how shady they move. I mean, Love can't even remember something where she was yelling about a PowerPoint because Judge Glanville had excluded it. She says, I don't recall that being the way it went. I don't remember that. She pretends not to remember something that, in my opinion, I wouldn't forget. Something that's intense like that, you kind of at least remember it happening at all. And don't just go, I don't remember that happening. I don't know. This is also a great, great point. Why would they go out of their way to prepare with them in advance? And if they did, the state probably would have came in today and been like, Your Honor, we would have been ready with this one thing, but we were being so helpful to the defense that we didn't get this other thing done. So it's like, there's no win. And then thank you again for those gifts, Sentinel. That was super nice of you. Chloe Albert's Revenge says, and Cardi B said she had bloody shoes, but y'all didn't go get her. Yeah, still stuck. I'm still stuck on that drip necessarily being an implication that a crime was committed. Like, that's a lot. Like, open TikTok, lady. Just open TikTok and scroll for a few minutes. And then Belle Louise says, maybe I missed it, but Kat, can you explain why the Supreme Court, federal/state, has not stopped this clown show yet? This is not justice. It feels like targeting. Excuse me, I haven't seen every day. That's okay. So there's been a few times where, there's been a writ of mandamus filed up to the Supreme Court of Georgia. And really there needs to be a situation that, while the trial's still happening, would warrant a request from the defense, or really even the state, to file up and say, hey, make the court do this thing while it's happening. And we've seen that, for instance, when Brian Steele was held in contempt. They wanted a writ of supersedeas bond to help make sure that Brian Steele wouldn't actually be held in custody. So they had filed that, and then the court obliged. They're like, yeah, not going to do that. There's some other ways. For example, if these motions for recusal, motions for mistrial, they get denied by this trial court's judge, the person who filed it can say, hey, I want to request a certificate of immediate review. If the judge grants that, what that means is they can fast track that particular issue in that particular filing to the Supreme Court, the appeals court. But so far, when it has been requested of Whitaker, it's been denied. So there's mechanisms for it, but they're rare, they're constrained, and when asked for those certificates, they've been denied thus far. So really, where something like the Supreme Court of Georgia would become relevant would be on appeal. So way, 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 way far down the road, years down the road. So not a optimistic answer by any means, but that's why we're here. That's why we don't see someone stepping in. It's just not the way the system's set up to work. And then FFS says, in the words of Young Buck, you ain't a Crip like Snoop, you ain't a Blood like Game, 2003. Also, can we get an indictment on the pastries? Yeah, indict them, bring them into court. We want to try the pastries. And then Gwennon, type 1 in the chat. Put 1 in the chat if you're an unindicted co-conspirator. Don't tell love. Mark Lyon says the state should indict every bachelorette party that ever went to Vegas or Nashville. Heck yeah. Or anyone that's ever posted something like keys to the city, or like just phrases that you put in your social media captions. It's like an influencer thing to have witty and kind of risque captions. So it's not reasonable to conclude that every single caption that somebody that the state thinks is associated with YSL, whether as a record label or in gang activity, that anything they say in a social media post is supposed to be an admission of some criminal activity. Like, it's just a wild concept to me. My head does not even want to try to wrap around it. And I guess they'll say, well, a jury can decide. And I hope they have more than 2 pennies to rub together of common sense. Thank you so much, Mark. Jake Kellerman says, I thought we made it out of the plaid section of Love's Closet. I gotta find some black and white plaid. I don't have anything that looks like that blazer. I have something that's like sort of black and white. Maybe tomorrow's stream. I gotta imitate her outfit. No, but we're back. We are back with plaid today. And then Delicates of Life says, does Love have kids? Sons? Just curious. I don't think so. And that kind of explains a little bit too, right? Like, just out of touch. Yeah, and one way that they could be in touch with the youths in Atlanta, in Fulton County. Maybe if they finish building and opening that youth center. But they didn't, so we'll just stay disconnected from the way that young kids act, communicate, hang out, chill. the way people talk on social media in general. We'll just ignore it all and stay out of touch. And just assume that everything that we read that we say can help our case is nefarious. Great point, delicates of life. Thanks so much. And then Ike says restroom breaks are also known as defrosting. Yeah, so Queen Leah, I would think, she's a prosecutor, so she's not that out of touch. But at the same time, if she's been looking at this case for several years now, it just seems a little bit like, I get certain things. You put slat over someone's grave on their grave marker. To me, that's a little bit different than someone just saying the word slat. And the person saying it is someone that's not indicted in anything. And you want to bring that in against everybody else that's sitting on trial. Like, there needs to be a little bit more than that. Because at some point, it just becomes inherently prejudicial to show a bunch of footage of people being corny, cheesy, showing guns. Like, there are people, and I think it's corny to just flash stupid. I hate when I see a picture and someone has their, like, no trigger discipline. They're just trying to flash their guns in a social media post, but they're sitting with their hands right on the trigger, finger right on the trigger. I think that is so corny and irresponsible that if I kept seeing 12, 11, however many videos and pictures of that type of thing, I would just be like, these people are a mess. They're doing all this to chase social media. They don't care. They're dangerous because they can't even be in a house full of people and respect the people they're around without putting their finger on a trigger. I think it's reasonable to think that showing this type of thing over and over becomes more prejudicial than probative. Even if you think that once in a while, maybe showing that someone had a gun can help you explain a possession charge in the indictment. So where I really think it's out of touch is just the concept that sometimes these are not people flashing guns because they just got done killing somebody. It's the idea that people would do it just to show they're cool in general. Not cool and affiliated with a gang or engaging in gang activity. But it's just something that people do to be cool in social media posts. And I'm not sure that Love is unaware that that's the case. I think you're right there. She's just pretending there's no possible other explanation because she wants to make that one explanation the explanation. But Judge Whitaker seems out of touch. Judge Whitaker doesn't seem to understand why somebody would show a gun in a social media picture unless they were bragging about killing someone. Definitely think the judge is out of touch there. And then hold on, do you mean like to have people up? I don't know if we're gonna get a long break today, but maybe on like Wednesday when we do like those long days again, we won't have a half day because I guess tomorrow's a half day too. We can do a panel during lunch. Yeah, so Ron Barnes, the deal is everyone else does it, so why not? And then Eslo says defense needs social media expert. Yeah, I think that's going to become something kind of common. Like, honestly, just a cultural reference expert. It could be a consultant. It doesn't need to necessarily be someone hired on a staff, right? I feel like that wouldn't be a good move. Because if you're dealing with, a specific culture in one case, it could be a different thing in another. What's that case? The Latter-day Saints case with the radio. If I hire a culture expert at my office for something like that, they're not going to have the same expertise in every other case. But I think hiring as consultants is definitely something law firms need to do. I think it's something that prosecutors need to do just to have an understanding of the things that they're looking at. And it's got to become more and more common because this isn't the only case where we've seen someone look at social media or maybe phrasing in a text message and just had no idea of what that thing could mean other than the absolute worst that they'd already concluded it meant. That would be so funny. Wait, where'd it go? The defense calls Dr. Umar Johnson. Hilarious. I know that would be a well-watched trial day. Heck yeah, hire Brina. And that's a good point too. So Jay says that's how a lot of these rappers that are convicted felons have guns in the videos because they're prop guns. Yeah, that's true. I still think there's stupid people on social media. It's always someone like younger and they're just, the trigger discipline is not great. And to me, I don't think it's a prop gun, but maybe it is. Maybe it is. Yeah, that's true too. She could know, Judge Whitaker could know exactly what she's doing. I think she knows what she's doing, but I don't think she's aware of her own. Like, I think she believes that everything she sees is only explainable through her own lens. And she's making these decisions as if, well, these guys must clearly be guilty as charged. So this evidence that I'm looking at can't be prejudicial more than it is probative. The probative value can't really ever be outweighed by the prejudicial nature of it, because to me, I'm looking at it as all being probative because I don't have any other life experience that would explain why it might not actually be probative. Yeah, and who knows exactly what qualifies as a gang expert. We'll see if Whitaker changes on what she thinks qualifies.
All right, we're looking at the social media posts for Mr. Sledge. Which ones do we need to litigate? So for whatever reason, I don't seem to have the, let me see if I can find the numbers. They were a lot clearer on the last group. So give me a minute to find where number 3 is.
And Judge,
Yeah.
am I incorrect? I believed that we had gone over Mr. Sledge's social media post. We did not?
I don't know if I'd have to.
I thought that we had gone over them. Some of them at least, and particularly number 3, if that's the one that's labeled State's Exhibit 397Y.
397Y. No, I've never seen that.
Where we talked about the fact that it was the night of Donovan Thomas's murder and that he was
Yes.
posting.
Yeah, I
Patriots
remember
Day.
talking about it.
Okay.
We haven't reviewed this, and my objection to this is the state keeps inserting these January 10th, 2015 captions on these photos.
We don't,
If you look at every other Instagram photo, there's nothing like that. But then on these January 10th, 2015, they're inserted, and that's inappropriate in my estimation. And that's my objection.
Sustained. I don't think y'all need that. That's not what it really looks like.
that's fine. And we intend to show evidence that it was posted on January 10th, 2015. So we can take out that little square that's above
The
the.
hover, yeah,
Yes.
okay. All right, so that objection is sustained.
And number 4, the same thing.
Okay, they'll adjust that one as well.
That's right. And so Judge,
Yeah.
as I said the other day regarding the other inquiry about that, as I'm asking the court, if we establish with the witness who caused that to pop out.
Right. I would think that if you are having that witness testify here, you know, here's me looking at the social media and here's what I do to find out the date it's posted and this is what it looks like. Here's, you know, when I hover. I mean, I think that's fine and you can show that, but I think the exhibit that goes out to the jury needs to be just what it looked like, not with the hover.
So if, no objection to that ruling as to showing the exhibit with Mr. Sledge, right? Because he
Right.
wasn't the one that hovered.
Right.
But as to, for instance, ADA Sprinkle, who would have been reviewing it and who would have been hovering. Screen grabbing what shows up when he's looking at a social media page is relevant, we would argue, relevant evidence of the date that it was posted that goes beyond the memory of.
All right, what does the defense say to that? Like, the proposal at this point is not to have the hover part with these witnesses who posted or whatever, but with the investigator or prosecutor who, I guess, was in charge of collecting this evidence and who confirmed via hovering that that was the date it was posted.
If my stance, the state keeps saying Mr. Sprinkle did it. I don't know that to be a fact. So if they produce the witness who hovered.
I mean, I think that's their plan, right? Is to put Mr. Sprinkle on the stand and he will testify to that.
Sprinkle, Gaither, Dennis, whichever one, because there are multiple
Okay.
ones.
Well, so that's my whole point.
So
If you're
yeah,
saying
whichever,
Sprinkle-
that will have to come in through whichever witness did the hovering.
That is what we're saying.
Okay. All right. What else?
Number 5 is.
Well, could he just,
I'm going to object to number 5.
which one?
It's
I
it-
can't tell what number 5 is. These
I'm-
aren't labeled the same way as the other ones.
on your top right of your screen. Do you have something that says 5 of 37?
Okay, yes, and they're also labeled. So that's Stacy Exhibit 399 Yankee. So that's the video. It's 39.
Okay, got it.
So
Do I need to watch the video? Because if so, I need to pick which media player
I
I'm
can,
gonna.
you can just, I can hit it. It's a regular one.
Well, I'm not on Zoom, so do I just need to
Oh.
hear it?
I think
I
hearing
can
it-
join Zoom, but I just hadn't yet. So give me just a second.
Yes, sure.
Do I need to see it or just hear it?
I think hearing it would suffice.
Okay.
That's,
Do you want to? This is him. 5 of 37.
To fill the screen.
I was like, don't turn the sound off. We want to hear it.
okay.
You lied to your mama,
I just forwarded.
but you get in the courtroom and in the investigation room and tell them punk ass people the God honest motherfucking truth. Pussy ass.
I didn't stop it. Let me try it again.
Yeah, play it again.
It's loading.
Lie to your kids, you lie to your mama, but you get in the courtroom and in the investigation room and tell them punk ass people the God honest motherfucking truth. Pussy ass.
So
I thought we did discuss this one already.
There was a prior video that's been admitted into evidence where this is my recollection, and Ms. Williams, if this is not correct, I apologize. Mr. Williams, we discussed this one as well?
we did.
Okay.
We did.
Okay, so on to the next one we didn't discuss.
I know my next one I had object to is number 11.
Okay, can y'all tell me what state's exhibit number that is?
Yes.
And number 11 is, it's State's Exhibit 406Y. And to me, it seems to be a collage of other photos with Mr. Sledge and other individuals that show up in
Uh-huh.
other exhibits. There's no new associations that are revealed by
Okay.
State's
Is-
Exhibit 11.
All right, is the point of this one the post that goes along with it?
Yes, Your Honor, just 1 second, we're pulling it up. You got it? Yes. Just to put on the record what it says. I love my slimes, well, snakes, and they green heart emoji me. And it's a photo grid of Mr. Sledge and other YSL members. So yes, the post and the association and the public proclamation of that association.
All right, so similar to when Mr. Zachary is himself saying, yeah, these are my YSL people and here's me with them. If we don't already have something, I mean, we may have these individual pictures, but we don't have this assertion yet by Mr. Sledge, then that is not cumulative. So that's admitted over that objection.
Okay. Number 13 has a similar caption.
What's our exhibit number for that one?
408Y.
Okay, thank you.
Has a similar caption, and it seems to be my client dancing.
Okay, so that one's a video, which I can't open. And I
Show
don't know
us.
why, even though I'm now on Zoom, I can see it on Miss Persifield's, but I can't see it on mine.
Ms. Hilton, if you could share via Zoom, that would be helpful.
Ty Wayne says I wanted
Oh,
to
there
hold
it
back,
is.
but
Okay.
something's off with Judge
Got it.
Whitaker. Put a 1 in the chat if you agree. Put a 2 if you're still holding out, thinking
Are you
she's
gonna hit
fair.
play?
Put a 3 if you're just undecided in the middle.
Share the sound.
So 1 for something's off with Whitaker, 2 for no, nothing's off, and 3 for undecided. Ooh.
So this is yours. Okay, all right.
Lots of 1s, couple 3s.
Okay.
We have a 2.
Is there anything added to this one that isn't captured in the still other than a good beat?
Oh, she likes the beat?
You just created a soundbite. The still showing all of the members of YSL. And
There we
the
go, we got a
post
2.
Are the most pertinent parts.
All right, so then
0.
y'all don't really need this one, right? I'm asking, is there,
We don't need the
we
video.
just looked at number, was it 11 that was like the collage? Are there people in this still or part of this video that aren't also in that collage?
Mr. Williams, I believe, but I'm checking to see in the
Okay.
collage whether Mr. Williams
All
is in
right.
the collage. Mr. Is he in there? You can't see his face in the collage. So the still shot is in the collage from the video in the upper left-hand corner, but
Okay.
Mr. Williams' head is turned away from the
Okay, so
camera
if you
in the
want to
video.
capture a still from that video that shows Mr. Williams, then you can use it.
Okay.
Okay. Next.
Number 14 is the same thing.
14 is which exhibit number? 410Y or
09Y. Oh, sorry.
409Y? I thought that's what we were just looking at.
And
Oh,
then Ashley
Oh, no,
Merchant
that's a
said on
different
some
one.
podcast, I think it was Professor Nez, that's probably the one you're referencing, that the
okay,
quickest
that
way through this
seems
nonsense
cumulative.
is forward.
Unless there's some reason that the state believes it's not.
These are different people, and this is, can you hit play? This is Mr. Sledge, Trantavia Stevens right there, and Mr. Williams' sister, as showing the association, as showing, again, when they're talking about, I love my green heart, green snake, red hearts, emojis, we have jail calls that we have asserted are co-conspirator statements that involve Mr. Williams' sister.
Okay.
Doug Weinstein looked over it.
I didn't know that this sister is the sister.
There's another exhibit, 405Y. The state, this is an unrelated trip to the club, and now we have 2 videos, a collage, and I think 2 photos
Okay.
documenting this night at the club.
So which videos are, because I haven't, unless there's some video that you just didn't.
Well, I didn't object to it.
Okay.
It's 405Y is a picture of everyone. From that same
And guys,
night.
I'm dropping the link to the
Okay.
Ashley
Does
Merchant
that
interview
show
in the
the
chat if
sister?
you missed it.
I can't.
Does the state know whether the photo that's a big group shows Mr. Williams' sister?
Okay, 2 things. So I don't know that it's the same night as Mr. Sharps argued, but
Well,
I'm
I'm not
looking
sure
at
that's
the-
relevant. If the point of it is to show their association, then whether it's the same night or not.
Okay.
Does this show Mr. Williams' sister with this, general crowd of people?
Okay, we're going back to 405, was it?
Yes.
This one? He says State's Exhibit 405.
It's picture number 10.
Okay. Can you go down?
Okay, well then, that video then shows something that's not shown already. So that video is number 14. So that's admitted over objection. What's the next?
410Y. It's some sort of meme that was shared by apparently Mr. Sledge.
I'd get annoyed as the juror watching videos of people at the
Makes
club.
no
Like,
reference
what are they trying to make out of
to
this?
anyone in this case.
So, Your Honor, the reason that this meme, we would argue, is relevant. You're about to get 20 years for a crime your best friend did last night. Do you snitch or take the beef? You tell the punk ass police to do their fucking job. So Mr. Sledge, in his interview, he essentially said as much. On his video that the court heard a moment ago, he intimated as much. But what he's doing in this particular posting is making a public proclamation displaying their belief towards snitching. You have not only Mr. Sledge making that lie to their mama and lie to their sister, get into court and tell the God is on his truth. You have Mr. Williams, who posted a similar video with Mr. Sledge apparently in the background, mumbling, saying, sort of signing on to whatever it was that Mr. Williams was saying at the time. We would argue this right here is more of that, this is who we are. You know, we don't snitch. You let the police do what they're supposed to do, but you don't tell on your friends. And under the circumstances of this trial, especially
Which of these
considering
people
some
went
of the
to
testimony
jail
the jury
for
has
their
heard,
friends?
we believe that this particular type of posting, public posting, is very relevant to explain some of what the jury has seen.
Okay.
Two things, Your Honor.
Yes.
first, the state has said they have a video of Mr. Williams saying things about snitching and Mr. Sledge saying things about snitching. So this is cumulative. Also, you know, the state keeps saying they feel this, they're saying this. Mr. Sledge owns and operates presumably his own Instagram account. At no point does he make any reference to anyone involved in this case. At no point is he saying he's speaking for YSL. At no point is he hashtagging YSL or at YSL, anything. He's making a comment as an individual on his individual page. And he's really sharing a meme, but I don't know why that's relevant. And it's certainly cumulative when the state just said they have other people, they have him actually giving a statement and they have Mr. Williams giving a statement. That's already in evidence.
All right.
This particular assertion, it doesn't just say no snitching. It says you're about to get 20 years for a crime your best friend did last night. So the fact that Mr. Williams has made an assertion that is very similar in nature to the one that Mr. Sledge has made, and then the fact that this particular posting references not just telling on someone, but you're about to take the heat for something your friends did. It's displaying yet another message to the public about YSL and we would argue their willingness to stick together and stand on, you know, their loyalty towards one another. The argument, I don't know that it's so much necessary to say that it's, you know, it would be our argument that he is asserting the sensibility, the way that YSL operates. That's what we would be doing. It's proof. We would argue it's our evidence of the way that YSL sort of.
All right, I'm going to
promotes
sustain
itself.
that objection on 403 grounds. What's next?
She just wanted to end the word salad.
413. Why?
He's probably like, I've seen one of these memes before.
Is this the same video that was I believe 399 and 413 are the same. Am I incorrect?
I don't know. Are those the same video?
Oh, I'm sorry, it's a different video, but he's saying the same thing. He says the same thing twice about snitching and things of that nature.
So, do I need to hear what this says?
Hey man, nigga getting to tell lies to his kids, tell lies to his mama, but get in the courtroom and tell the judge the God on the truth. Y'all pussy ass niggas. We call you whole ass niggas trip now. Fat hoax.
So I think it's actually, and I think it's the same words. One time he's wearing a white t-shirt, it appears, and one time he's wearing a white tank top. I don't know why he recorded it twice.
We can just use this one, especially since he says black at the end.
Okay.
BLATT, black.
All right, so this one, and what's the number that you're not going to use instead?
399Y.
399Y will be out then. Okay.
And Your Honor, the other issue is that posting it multiple times, posting their feelings about snitching multiple times, it is meant to reinforce how strongly they feel about it.
All right, so what were the dates of the two posts? I had understood you to say
Maybe engagement
that
was
you
better a
wouldn't use
second
the other one, but
time.
are you now saying you do want to use the other one?
So we would ask, yes, to use both because if one is on July 19th, 2015, and the other one is on 399 is on July 19th, 2015. And the other one is on March 25th, 2015. we would ask to be able to use both.
Okay. Well, I mean, that does show that this isn't a one-time thing. I guess at least this guy wants to reiterate it. So I will admit that then.
This is not how Instagram works. People repost stuff all the
What's
time to get
next?
more likes and to get it to more people.
416Y. Relevance.
What's the relevance of this?
Get it now. Ooh.
So are they smoking in the club again? Oh, they have a snake.
So who all's in that?
Snake is in the video, Your Honor.
Martinez Arnold, Diamante Kendrick.
I mean, I can see the relevance. What I'm wondering is whether it's cumulative. But Arnold and Kendrick, I don't think we've had any, at least in what we've reviewed so far, the two of them.
They've both pled together on a count in this indictment. I mean, there's going to be absolutely no. No, not on this indictment, but there's a count in this indictment,
Right.
in an overact where they both pled.
Yeah. No,
So-
yeah, no, I'm saying we don't have any videos or photos that we've at least looked at today that have the two of them wearing YSL garb together, right?
I don't think we have.
Okay, well,
We yeah. Not so far.
okay. Anybody dispute that?
I don't believe so.
Okay, then that will be admitted over objection. What's next?
Number 22. It's another video that I don't see the relevance.
Okay.
417Y.
Thank you.
Bitch, we out doing a little shopping, bitch. How we having this shit?
We're gonna make fuck these punk. Hey, tell them I said we can go make a phone, man. We're doing a lot of little shopping, man. You know, fucking up Scott. Chinchilla in the shop.
Yeah, turn up.
This is just corny to me, but not indicative of
So that was the
anything
extent of that. Did the court-
misbehaving.
Was the court able to see it?
I mean, tell me who all's in it and
It's
why
mis-
it's.
Shannon Stillwell, Diamante Kendrick, Antonio Sledge. And this is a couple of months after Mr. Thomas's murder. Diamante Kendrick is in the coat that he is wearing the night of Mr. Thomas's murder. And they are still very much associating with one another. One of the arguments that was made the other day by, I believe, Mr. Sharp was he objected to part of the factual acknowledgement of Mr. Sledge and argued that he would have had no basis for personal knowledge of information that had happened on a particular night.
Okay, well, this might show that as a foundation, but that's not for the jury, that's for me. So,
No, I'm just, as far as relevance goes, it would be relevant for those purposes.
We've just seen.
The co-counsel is emphasizing that jacket being the jacket that he was wearing. Mr. Kendrick, if we need to rewind it, we can show you.
yeah, I saw it.
Excuse me, I don't believe that's the same coat. I believe it's arguably similar, but I don't believe it's the same coat.
How do y'all know what he was wearing that night anyway? What evidence is in or gonna be in?
It's on video. He's clearly walking into a store that's a few 100 feet away from
Okay,
Mr.
and that's clearly him.
Oh,
And so
yes.
what does it matter that he's wearing the same coat later? It's his coat. I mean,
No,
why does
no.
that matter?
No, just
I mean, seriously.
in terms of one identification, I understand that the court is saying you can see him clearly on the photograph in the surveillance video.
Do we need to do a
But
video where Love wears the
also
same outfit twice?
He's with Mr. Stillwell, who is
Uh-huh.
also alleged to have committed the act with him 2 months afterwards, and he's with Mr. Sledge. So when Mr. Sledge gets on the stand and tells the jury, or whether he does or doesn't acknowledge that he knows.
All right, well, so then this might come in as impeachment evidence, but I'm not hearing. Like,
And-
oh, yeah, no, we never hung out, or we didn't hang out after that night because I was appalled at what they supposedly did, then yes, but otherwise.
And also, I think, and Mr. Kendrick filed an alibi notice as well regarding where he was at the time of the murder, so.
Okay, but it wasn't, this has no relevance to his alibi.
Not directly, just that it's further
Oh.
proof that that's him in the video and him at the location and him right there 6 minutes before the murder.
Okay, so then back to the coat being the thing that matters then.
Yes. Yes.
I guess if your client, Mr. Weinstein, is saying I wasn't.
He's not denying being
Well,
at the gas station. It's in the video. You can clearly see that he is
Okay, so
walking into the gas station.
What's his alibi? Then maybe I'll need to go look up the alibi notice.
He
I
was with Miss Morton later that night.
So it doesn't cover the time of.
No, he was
the-
with Miss Morton at the time of the murder.
Okay, what
But
time?
what the coats have to do with this, I have no idea.
I
And what a
guess
March video
It,
has to do with his
it's
alibi
some-
on January the 10th.
right.
The
so
time he was,
what's the time of the gas station video?
at the time, it was at the time of the murder. It was 6 minutes before the murder.
Okay.
Your Honor,
Now, hang on just a second. Sorry. And then is Mr. Kendrick's alibi that I may have been at the gas station 6 minutes before, but 4 minutes before through the time of the murder, I was with somebody else somewhere else?
correct.
Yeah,
Give me 1 second. Your Honor, I'm
okay.
sorry. Yeah. Yeah, again, there's no denial that he was at the gas station prior to the murder.
All right. But not, okay. So the code doesn't add anything to that.
But it's not the same. He's like my wife, Your Honor. He buys the same style coat, but it's not the same.
Whether it's the same code or a different code.
Yeah, it's
it
irrelevant.
doesn't show anything about
He said, yeah, because like
the
his wife.
viability of his alibi. And anything else before I exclude this one? No. Okay, moving on. That one's out.
23, Your Honor. The previous photos have 418Y have
Okay.
continued to show an association between Mr. Sledge, Mr. Zachary, and Mr. Stillwell. That's been established through the photos already.
All right, and who is this we've got right now?
That is Mr. Stillwell, Mr. Zachary, and Mr. Sledge.
Go ahead.
I would point out the caption that Mr. Sledge makes underneath the photo, gangsters sitting at the round table with 3 green snake emojis on March 4, 2015.
And those same emojis are what justified all these previous.
Okay, so is it, are you making the argument gangsters sitting at the round table is like a reference to King
Gangster,
Arthur and the Knights of the Round Table or what? Or
No.
just the fact that they're saying gangsters?
that they are calling themselves that he is calling them gangsters, because I believe at some point there will be, we've heard at least one witness while we were talking about gang say game, like GAME. So I believe that there may be efforts to distance YSL members. Well, there have been consistent efforts to distance YSL members from being gang members, gangsters. So we would argue that he is not just sort of making this, you know, oblique reference. He's proclaiming for the public something.
The generic term gangster is propensity, first of all, but secondly, this, if Mr. Sledge says something on the stand that's vastly is shocking to the state and they feel that this contradicts it, then perhaps there's another discussion. But in and of itself, until that happens, I don't know why this would be relevant to anything.
So remind me, the one that gangster in every city we go, that would show the same thing.
You didn't keep it in.
I didn't rule it out. I
You
held
didn't.
it.
We would prefer
So-
this one over that one.
All right,
Wait.
then that one will be
Hold
out and this one will be in then, but they kind of get to the same thing.
So, Your Honor, could the court give me?
Sure.
Okay. We're going
We're
to
like
choose,
debating
we would
words
choose the
again.
one closer in time to Mr. Donovan Thomas's death. So we would cede this one if
All
the
right,
court.
so then 418Y is out. And if it ends up being some kind of impeachment evidence, just sort of alert us before we use that.
Okay.
Okay. What's next?
Number 421Y, which is number 26. It's another group photo.
Heck yeah, FFS. Anything you say can and will be used against you. You don't need Miranda for the social protection, so be careful what you say online.
This is a picture that's in our indictment. I believe we may have even already admitted the photograph, but the caption is also part of what is important. So both the photograph, the caption,
I'm blind. It says
and
something
the
on my
fact that it's in our
family.
indictment alleged as an overact.
Love them to death. Real YSL. Snake, snake,
What do you mean
snake.
alleged is an overact?
The posting of that photograph was
The
alleged as
posting
an
is alleged
overact.
as an overact.
Yes.
Okay. Then, and so, okay, you allege as an overt act that they post things that promote YSL, and you showed this picture as an example, and this is showing that it was actually posted. Is that the argument?
Yes.
Okay.
I think that.
And it's a cap.
Yeah, I can see what the caption reads. I'm gonna permit that one.
Okay, now
Couldn't see what the hashtag said,
here
so
is and when I say here, I'm talking about 422Y
Okay.
is the actual post that does not involve anyone hovering over anything that says a date.
Right.
And I know the relevance of the date and the time. And so I don't have any objection to that, but that's the way I believe that these, not some manipulated timestamp on the upper right, but as it appears in Instagram. And so I don't have any objection to 422Y, but going back to that other
Right.
exhibit, which is 397Y, I would say 422Y is more appropriate.
Okay, and it actually, you can see down there at the bottom of the post a time and a date.
This is exactly like when we were talking about the other day where we had the picture with the pop out of the one we dealt with on Friday. We had both the pop out and we had the date and time. When I referenced to the court, we had both. So this is the same situation. So we would be introducing this one, and since it's no objection, we wouldn't have a need unless there's this argument about what date it really was posted to show the other one.
Use the other one. Okay. All right.
So
Thank you, Jason, for the super
This-
sticker. That's awesome.
next one, which is 423Y, that caption is already on 420Y. It appears that he's reposting something that some other individual who I don't know who he is, and I have no reason to believe that he's in this case, SMM body count with an X instead of a C, posted. And if you go back to 420Y, I believe, you see the exact same, I'll never switch up on my brew, I'm not a dub. So that seems cumulative, and quite frankly, I'm not a big fan, and I believe it's prejudicial to have a post by this gentleman, SMM body count.
Is
who we
brew
don't
like
even know who
bro,
he
like
is.
brother? Or crew? Oh,
That's a
I get it.
state
It's crew.
response.
I'm looking at the. That's fine. We don't object.
Okay, so they concede.
Or
that
concede,
They will
yes.
not use, what is it, 422?
Those dubs supposed to be duck with two
423Y,
C's.
423Y. Okay. Thank you. Next.
So I believe that this is a cumulative,
Which one?
I'm sorry, 426Y, number 31, photo 31, is a cumulative of the group
Hang on,
photo.
that one doesn't open for me. Too many things open. Okay, yeah, that looks like the same thing.
That's a cumulative of 405Y.
We're gonna put up both.
Okay.
Okay. We won't use both, Your Honor. We'd ask that the court allow us to
All right, well, choose
Choose.
now so that we know which one.
choose the one that is 405Y.
Okay. All right, so they will not use 426Y.
Oh, wait, his phone.
Okay,
Okay.
Don't understand the relevance of 427Y.
And then Apunanu says
so
two
there's a
evidence numbering
relevance
systems.
objection to this one.
I think there's just so much evidence,
His,
and they should be more streamlined because the court reporter had trouble
it's
catching
that
up when
he
she came
listed
in.
his phone number, and his phone number, by he, I mean, Mr. Sledge.
So I don't
It is-
understand why they're doing it like that.
So if he refuses to say what his phone number is or was at the time,
Or we could
then
refresh
you'll
his,
use it.
right.
Okay. which you could certainly just use it to refresh his recollection. Okay, so that'll only be in that eventuality.
Or if he doesn't remember even after looking at it, then we would have to use it.
Sure. All right, any others? We're almost to the end of this grouping.
Yes,
Bash
Your Honor,
Money Bass.
430Y,
Thank you so
which is
much.
Number 34.
I don't see a 430Y, but okay. Go ahead.
I just asked her hope she was dead. Motherfucker, yeah. I just asked her hope she was dead, man. She don't even know who that. She like, you crying.
Who all do we have there?
Don't we have Mr. Williams? We hear the reference to King Slime. Could you play it back again? Sledge right there, Mr. Williams right there, Mr. Arnold, Mr. Stillwell, and Mr. Kendrick,
I just asked her hope she was dead.
Darlington, and Kendrick,
All right.
and oh, Mr.
And when's this from?
This was from.
And also whose account? I'd be interested.
What, I couldn't hear what you said.
I'm not sure we know whose account it's from either.
We have it from YSL_Daddy on one.
Who is that? So I, the justification is for these videos has been, oh, it's showing promotion. And we don't even know who posted this.
But we have people who are in the video who can talk about the video. It's what's happening in that scene itself.
They're sitting at a table.
That he can lay a foundation for it.
Who, and this is going to be Mr. Sledge that
Yeah.
testifies to this?
Yes. And it's in this particular instance, this isn't so much as them promoting their violence. This is them referring to, we believe Mr. Williams is King Slime. This is them, all of them. I don't know that we have these particular individuals all at one time in a setting together. And we believe.
We're
and can
going to
later
play a bunch of
confirm
videos that
it is
this person's
Mr.
with
Williams'
this person here. We got to play this
Sky
one because this person's
House
with that
condo, but
person.
We'll confirm that.
Okay.
Sounds like a waste of time.
I would think that would be relevant. All right, so I'm going to overrule the objection to that.
And then
Right.
Cash Money Cass had said, motion to call the CEO of Urban Dictionary to properly explain what drip and other slang means.
Just 404Y, which is number 37.
And let me say, let me go back to that one for a minute. Sorry, since y'all don't know who posted it, I mean, if you figure out who posted it, that's one thing, but if not, we don't need to show the handle or whatever of whomever the poster is, okay?
Yes, Your Honor.
All right. Okay, now back to the next one.
And Bash Money Bass
It's the
made
last one, Your Honor,
FFS spit out his bread
404Y,
bowl.
Number 37.
All right. Have we already talked about this one? Oh, this is,
Stop putting me on fucking fake pages. Cause I don't give a fuck, man. What y'all say, what y'all do. Anybody want to see Monto? I'm here. I don't hide. And I do not run for fuck niggas. You did.
It sounds like something somebody could say
This is
independently
the
on their
day
own.
after the Adele Drive shooting
okay.
that Mr. Sledge and others were convicted of.
What's the objection?
I'm going to withdraw my objection.
Okay. All right, so that is that grouping of social media.
I feel like that some of the stuff looks worse
I
for
think I might
like
have to go back
Sledge
and
than it
get
looks
into
for
that
the co-defendants
Dropbox
in this
again.
particular trial. Yeah, I think Sledge could very well be another I don't recall. YSL Beatty Hingerty. Yeah, and this is great. A great point, Satchel. So, and just
All
how a
right,
juror
the
is supposed to
next
correlate all of this
folder is tattoos.
is a mystery to
is
me.
What that folder is called, or do we have objections to anything in there? I mean, looks like a lot of them are the same picture over again. So at least
He's like,
I would
"Please,
think
someone
half of
object."
them, we don't need the same thing twice.
Did you guys see that Subway contest where if
wouldn't
you
be
change
putting
your
in
name to
multiple
Subway
Beyond
and get it
that,
tattooed, you can get free
Any
Subway?
objection? I mean, I assume he's going to testify that all of these are somehow gang-related tattoos or what? Because if they're just art, then that's not relevant.
We're not going to put in all of them, just the ones that reference or pertain to his, and I mean, he'll be here, so we may not
Right.
even put him in at all. He can show the jury.
Well, I don't think I want him stripping down in court.
Not
so.
all the way.
So if he wants to show us what on his forearm, that's one thing. Otherwise, I'd rather let's use the picture, okay? I don't know. I can't get an answer to that. Do you know which ones you're gonna intend to use that you believe are relevant to an issue on trial here? That he can't roll up his sleeve and show us? Are these videos? Are these videos or stills? Yeah.
I think we're not going to need to use Mr. Sledge's tattoo photographs.
All righty.
And yeah,
Okay.
I don't think at this time.
So I don't know what that, then there's an image that is, oh, it's a video that isn't in the other videos. What's that one? Is there an objection to that one?
I'm sorry, Your Honor, I just messed up my computer. Your Honor, could you direct us to the video you're speaking of?
I mean, so I opened up the Dropbox and, you know, went to Sledge's folder, and then within that folder,
Okay, I'm sorry, I just clicked on it. I think that's the video. Is it the image?
yeah, 0156, whatever. Yeah. So is that objectionable?
No.
Okay. Any of the other items in that folder? And they're marked with exhibit numbers.
Is the court asking whether, oh, okay.
I know that the state's position, I assume, is y'all intend to use those and believe they are admissible. So I'm asking if there an objection to them.
So the plea agreement, I've already
Okay.
thinking about that.
Yeah, and so, yeah, it's a little more helpful actually when I looked this weekend to see what it is y'all are talking about. And I would think whether that comes in or not depends upon how that witness testifies. So
When you're saying that comes in, are you speaking specifically?
this, I'm looking at the, whatever it is, December 27th, 2022, several page. It's called plea agreement, but he's initial different factual assertions, and that's the one I'm talking about. It's 396 YC, Y Charlie, Yankee Charlie.
Yes, Your Honor. And the terms of the plea obviously are fodder for cross-examination.
Right.
I would concede that potentially, depending on his testimony, statements that he acknowledged that would be inconsistent with his testimony could possibly be prior inconsistent statements. I would concede that fact. So I agree with Your Honor that to deal with the admissibility of the factual acknowledgement section, we would need to hear his testimony. My specific concern dealt with number 8, and just as I had concerns about Mr. Zachary and Mr. Copeland, whether they were in their prior statements, whether they were speaking out of actual firsthand knowledge or if they were speaking out of inadmissible hearsay or rumor or speculation. I don't want Mr. Sledge to be cross-examined or to be impeached with a prior statement that was based on that the basis of it was inadmissible to begin with. That's my concern.
Well,
And all I can say, and I'm not Mr. Sledge, so I cannot answer this for Your Honor, but I can say from my understanding from working on this case, that number 8 is not based on anything that my client has told him, and it's not based on firsthand knowledge.
I think that may just be something you'll have to explore, because he initialed and signed a sworn statement saying, I personally know this. Maybe he doesn't personally know it and it was a lie, but I mean, they've gotten that there for a reason. And that's just going to have to be something y'all explore with regard to his credibility. I mean, he is right here asserting in this document, I do personally know it.
Well,
So,
I understand what you're saying. And, these are not, I understand he signed it. He did not write it. And so personally knowing to a layman can mean a lot of different things.
yeah, he had an attorney at the time, right?
He did.
Yeah, so I think that, I can't keep it out on that basis. All right, what else?
We briefly discussed the plea transcript. I don't know under what circumstance that would be admissible.
I would think that would also be a impeachment item. Would y'all only intend that for recollection or impeachment?
Right, recollection or
Okay.
Okay, and then we also have a gang profile, which is filled out by someone. I don't know who wrote this. I don't think we know. We've been given a bunch of these. I don't know if we know who wrote any of them, but it wasn't Mr. Sledge.
Right.
So.
And guys,
would not
the
introduce
judge
the
hasn't
gang
gone over Doug's
profile as
motion
an
yet,
exhibit
no.
Through Mr. Sledge, we may use some part of it to refresh his recollection or something like that. It would be, because it would be a document that details certain incidents that involve Mr. Sledge. And it has photographs of him in
Okay.
it. We wouldn't be just whole hog introducing that.
All right, so this is not going to go before the jury.
Right.
Y'all may
We would,
potentially refresh his recollection
It's just that-
over something like this. Okay. All right. Okay, that takes care of these sledge exhibits, right?
I believe so, Your Honor.
Okay, so who do we move to next then?
And Chloe Albert, all I'm thinking is someone taking the mannequin, going into the Nike store, following the Just Do It slogan, and being compelled not to buy shoes, but to steal the mannequin in furtherance of activity. So that's the love logic being
Sorry,
applied there.
I have to keep reopening the Dropbox for some reason.
This is a great point from Garrett too, that rappers need disclaimers before every social media post now. What we're about to see is for entertainment only, right? Put that caption there, the disclaimer, and is not an admission of guilt or an implication of any activity. Like, it's crazy. Like, if there's an artist that's trying to sell, and it could be a writer too, you want to sell a movie, you want to sell a book, you want to sell a song. Part of it is selling the image. We haven't really heard like free speech arguments made today either, which has been interesting. Probably because that's very much Steele's wheelhouse.
Looking at the witness list, we've talked about Burnett, Sledge, and Zachary now. Thorpe's going to be moved to a bit later. So Bean.
Not yet, Your Honor. There was one that we can talk about that I think merits conversation.
Okay.
So Mr. Kendrick pled guilty in 2015 when he was arrested with Martinez Arnold in October 2015, where they had the two guns, one of which was stolen. In the plea colloquy, the prosecutor, as a factual basis, asserted that YSL is a gang and that Mr. Kendrick is a member of YSL. And Mr. Kendrick acknowledged that and agreed to that. And so we intend to introduce evidence of that against Mr. Kendrick during the trial.
Okay.
We're absolutely going to object to the entry of not only that colloquy, but any plea that reflects a gang charge that Mr. Kendrick pled guilty to. Mr. Kendrick, to my understanding, I mean, that's a decision he's going to make, but I have no expectation that I'm going to have the opportunity to cross-examine him. It was a testimonial statement. He was in court speaking to law enforcement for the purposes of securing himself the best deal possible. And certainly his acknowledgement, admission, or his testimony, I would say, is what it is, out-of-court testimony, or out-of-court testimony as applies to this case, affects my client. A element of this whole case is whether YSL qualifies as a criminal street gang under the law. Mr. Kendrick provided testimony to that, that I will not be able to cross-examine. And so we are going to object to any entry of the plea to any gang count and any colloquy during the plea regarding the nature of YSL, according to Mr. Kendrick.
And Your Honor,
Go ahead.
the court can limit the jury to consider that against Mr. Kendrick only.
Go ahead.
That would be wholly insufficient to protect the rights of Mr. Stillwell and the others, quite frankly. A curative instruction or a limiting instruction is not going to suffice. And the state can try to prove their case, but they cannot try to prove their case with Mr. Kendrick's statements during a plea.
Well, I'm not sure that's true. I mean, if it is admitted only against Mr. Kendrick and I am Kendrick's, and I tell them that that's all it can be considered
Kendrick was right.
against, we'd have to craft the right instruction, but I mean, it's out there and it's evidence. And I mean, I agree it's testimonial, and so it shouldn't come in against anybody other than him. It can't come in against anybody other than him, but seems that it ought to be able to come in against him. Are you saying there's just no way to limit it?
Go ahead, Mr.
Over Steele.
Yeah, and I agree with Mr. Shart. That is asking the jury to climb a steep hurdle. And that's why Bruton says that, yes, you can limit the statement. It used to be, as the court may remember, on a Bruton issue, if Mr. Kendrick made a statement, he made a statement in this case on October 6, 2015, and he implicated Mr. Stillwell, or he implicated Mr. Williams, et cetera. It used to be that there was an instruction given, going back to common law, that it could only be used against Mr. Kendrick. And the court said that's not good enough. In a joint trial, the jurors can't be expected to follow that instruction. It's you said it earlier too. Presumably the jurors follow the instruction all the time. That's what we presume. But in Bruton, that's why we excise or redact.
Right.
And here, it is an essential element of this conspiracy in count 1 and several of the gang counts that YSL is a criminal street gang. And now you have, and that's what I was saying before, and I'm looking for the cases.
Right.
But for Mr. Kendrick to get up and say, not get up, but for his plea colloquy to say, I am a member of YSL's criminal street gang, that instruction has to be airtight. Otherwise, he needs to be severed.
I mean, I agree that the instruction needs to be airtight.
Or he needs to be severed, or it's excluded. And I gave you a case when you first came on the bench here. I gave you, if you remember, if you don't, I could give another copy. United States versus Vendetti, V-A-N-D-E-T-T-I. I gave it to everybody, or at least the Ensemble Court in the state, and I think Mr. Weinstein. It's 623 F second 1144. It's the Sixth Circuit. It's 1980. It's good law. And I also cited State versus Jefferson, which is 302 Georgia, 435. That's 807 Southeast 2D, 387 2017. And they just and it's State versus Thomas, THOMAS, 364 Georgia PO 148, Division 2, 874 Southeast 2D 195 2022. But the bottom line, Your Honor, is I would agree with the Honorable Maxwell Shart that a instruction for that type of that is explosive evidence that goes directly to the essential elements. So I do not believe that instruction would cure any type of fair trial for the other people in this case.
Just briefly, Your Honor, we would object to any severance at this point in time in the case.
All right.
Put them in a tight spot. Find a
I mean,
solution.
I've read Vendetti, and I don't think that it actually stands for the proposition that you're arguing it for right now. I looked at the other two as well. The guilty plea of any non-testifying co-defendant can't, it's not proof of guilt for any of the other co-defendants. I mean, I agree with that, but that's not what it would be offered for. Y'all, the state, need to come up with an instruction that you believe will insulate the admission of the plea colloquy, the part that you intended, where if he says, yes, YSL is a gang and I'm a member of it, from any Bruton-ish type problems.
This is coming in through Thorpe, right? She wants this to come in through
You
Thorpe.
need to do it at, before that's admitted, not just at the end of the trial. It needs to be provided to the jury at the time the evidence is admitted.
Understood.
I think the defense, I know they want to avoid it overall, but I think the defense can wrap Thorpe up because he's going to want to act like he talks and understands what everybody's getting
Right.
at. So I think he'll very easily
I
concede
mean,
to
I'm
the
not-
defense saying,
I don't
you're
think
aware of other
it's- I
people
don't
taking
think
pleas,
that
right?
The law provides that it needs to be excluded, just that it needs to be appropriately limited. And if you can find other law, please forward it to me.
But ask
But I don't
Thorpe, are
think
you aware
those
that
three
other
do it?
pleas in this case, people said that they didn't know what they were signing to. So they have a way, even though they can't ask Yak, like, did you sign this with a
And-
misunderstanding or under duress?
Let's see. So
They could
Thomas,
ask Thorpe similar questions.
give me those two sites again. Just let me make sure I wrote them down correctly. I think you said 302 Georgia 435
Yes, that's State versus Jefferson,
Jefferson. Okay.
2017, and then State versus Thomas, 364 Georgia PO 148, Division 2.
Yeah, got it. Thank you. Yes.
May we offer as well Henderson, just for the court's consideration. Henderson v. State, it's a Georgia Supreme Court case decided August 21st, 2023, 317 Georgia 66 at 77.
Okay. Is that a new one or have y'all given me that before? Okay. All right, I'll take a look at it.
That's gonna be Henderson v. State, 2023, 317 Georgia 66.
Okay. So you think y'all may have? All right. For a different reason. Okay, well, I'll take a look at it for this reason. All right, so we're gonna need to do some work on that one, but those are, I think we understand the parameters. Okay, so I don't know what, I mean, thank you whomever raised that, but in terms of going through what other groupings of evidence we need to look at in this first 30 witnesses. The next witness that is on y'all's list in order, generally in order is Mr. Bean. Is there anything from him that we need to look at? I think, yeah, no, okay. So no social media from him? I didn't even see him in this folder, but. No, okay. And then there's Kenya Morton, and there's maybe an interview from her. I don't know if you.
Her interview would not come in
Okay.
unless she's listed as the alibi witness for Mr. Kendrick.
Okay.
And we wouldn't be putting in her interview unless it was to impeach her.
Is the interview not helpful to the state's
All
argument?
right, so we don't need to look at any evidence that's gonna be used with her, right? Okay. Then Sprinkle, is there anything we haven't already talked about for him that? So he's got a folder. If y'all want to open up his folder. And then within his folder are lots of folders. So hopefully the defense has, in the couple of weeks they've had the folders and months that I guess they've had the evidence, made a determination as to what, if anything, y'all would be objecting to in this grouping of evidence.
Microphones.
I do have objections, but there's a lot here, so I don't. We can discuss certain things, as Your Honor sees fit. I will say I do have objections in this folder, though.
Okay, well, now's the time to go through them while we have some days without our jury.
Yes, Your
So
Honor.
let's dive in.
Okay.
Where shall we start? We've got an Arnold file, two Arnold files, Garlington, Kendrick's, other items, Stillwell, and then some, I don't know, looks like pictures maybe. Let me ask this. Is there something that y'all are more ready on and then we could dive into this tomorrow?
The
Would
Doug
that
motion.
help?
There. Could I discuss?
Sure.
When you're finished, we can make an announcement on the Marquavius Huey motion in limine to get that off of our to-do
Okay.
list.
We'll wait till after they confer. Sure. Why don't we just take a quick recess? That way, if anybody needs to use the restroom, y'all can talk. And if anybody else needs to use the restroom, they can go use the restroom. Okay.
Comfort break. Thank you so much for all the commentary throughout. And I wanted to come back to this real quick. So, Cutthroat Radio had said, upon information and belief, the state is losing. And I personally feel like that. But I think it's worth repeating. Don't ever underestimate a natural, I think jurors have a natural inclination that if we're here already, we could say beyond a reasonable doubt, has the state met their burden of proof to prove that these defendants did these things that they're charged with? We can say, at this point in time, we think they're innocent. We think they're not guilty. We think the state hasn't met their burden to show or demonstrate guilt on XYZ charges. But I feel like sometimes we always have to be aware that a juror could go in there and just be inclined to think we're here because someone must have done something. Someone had to have done it. So, and that's a really hard hurdle to overcome. So, but thank you for the super chat there. I'm with you. I'm just presenting the counter concern there. Amy Shares says, the B in front of the words is probably similar to calling something a bromance. Or like when I thought brew instead of crew, I thought it was bro. Or the club brucial thing is referencing to bruising because they were in a fight there. So they caught a bruising. Also, why not indict the Bloods and not YSL? That's a great question. Because there has to be this gang war. There's retribution happening. There's revenge happening. But all of this fuss, unless you kind of rope, I guess, YFN Lucci into it, who ended up taking a plea and is only supposed to serve 10 years, but he's eligible for parole already, I think. Or he could be eligible as soon as right now for parole. So we have a plea deal on the flip side of this. But what about everyone else? Like, if gang's been around for a long time, where's the action targeted against that? So great question. Thank you for the super chat. Lemuel says, the streets and Instagram don't mix the way they doing this. Half of ATL can be locked up on RICO. Yeah, and it's like, can you imagine? I remember back in, I don't know, like, I was like a sophomore or junior or something. Someone in my year ended up getting suspended, almost expelled from school for looking at airsoft guns. Like, like not real firearms. They're, I don't know the exact technological distinction, but they don't fire ammunition rounds. They fire like the little air pellets. They almost suspended just for looking up different airsoft guns. So there's that, right? Once someone thinks that you're doing something that could be bad behavior, they're likely to see what you're doing in the lens of it being bad behavior. And how do you fight something like that once somebody already sees it and is set on prosecuting you for it? So I definitely think this is a great reminder to people out there, like, certain things that you post for freedom of expression, or to signal to someone that you're going shopping, you have lots of money to spend. You know, maybe there's a consequence that maybe is undue. Maybe you shouldn't have cops looking at you just because you have a lot of money for some reason. But they could look at that and say, look, let's investigate this person. They seem shady. They posted this on social media. Like, you just never know. And thank you for your super chat. And then, Satchel, speaking of geolocation evidence, I'm not exactly sure what the reports Agent Bernie wants to bring in or will come in through him, but I believe a lot of that is cell data, and I think they're going to use the triangulation. I think they're going to use some location triangulation data with Agent Bernie, and that's going to relate to who was in the car, where those cars were on the night of January 10th in 2015 when Donovan Thomas was killed. So I think we're going to see that coming up. They said when Whitaker read the list, I think Bernie was the last name she said, before moving. Did they say they were moving Thorpe to the end of the list? So really, he's going to be second to last if Whitaker's order of reading was accurate. So I think we're going to see that within the next 3-4 weeks. So that will be perfect for you. We can see what the judge does with it after that Supreme Court ruling where, geofence can be unconstitutional. So we'll have to see exactly what that data is sourced from and what the judge does with it. Great reminder on that new Supreme Court decision. Marlena Mack, good to see you. Poll. So going back to the poll, which you guys, we had 53% said let the police do their job, which is a no, I'm not snitching, but it's a play on the quote that was in the caption. 34% said they would snitch to get out of doing 20 years. And 11% just said no snitch, but didn't pick up on the caption funny either. So most people said they wouldn't snitch. Others said they would, with 20 years on the line. So, and remember, Woody's definition, it's only snitching if you tell the truth. So that's an interesting, Marlena Mack had said in relation to that poll, I've been in that situation. I stood 10 toes down, never told me, and only got 6 months probation. So honestly, like, I'm happy to hear that you only got probation. Because I think sometimes pleading out to stuff can be a messy business, but I'm assuming you have no record, right? If you had no record, probably going to try to give you probation anyway. I'm glad you didn't have to do 20 years is the point I'm getting at. Because that's what that meme that was so indicative of something really happening in real life. That was the hypothetical in the meme, was that 20 years locked up. So, and thanks so much. It's good to see you, Marlena. Hope you're doing well with the NAR changes that came down on Saturday. Nancy New says, is anyone allowed friends or a business in Georgia? No, and it's kind of like discouraging the idea of shopping and spending money. Like, don't be flashy with your money because people are going to look at you sideways. Law enforcement's going to look at you sideways. Prosecutors are going to look at you sideways. You're going to end up as an exhibit. Your shopping is going to end up as an exhibit in a case. So, and yeah, the friends, so, this constant, I think 2 different times today, just for the stuff that they want to bring in, the social media posts they want to bring in through Sledge. So just his folder of relevant social media posts. 2 times, oh, these are the people you're sitting at a table with. Like, that just screams association. And I honestly think a lot of it will be lost on the jury. Especially Sledge could get up there and not even want to answer. He could be like Woody. I don't recall. I don't know. I don't want to testify. I plead the fifth. Who knows? Who knows? Thank you so much for the super chat. Chloe Albert's Revenge says, when people eat White Castle and post about their murder burgers, is that like a thing for the name of the burgers? Because they kill you. They're so good and steamy. I really hate to think what these airheads think they're admitting to. You mean White Basil, by the way. Chloe. Blowy. FFS says objection. Your objection? All objections. I do think Shart has lost a little bit of steam when he's describing why he's objecting. You know, some of them, he just said, this is what's going on in it. But, you know, cite the actual reason. You know, it's cumulative, it's speculations, foundation issues, it's Rule 403, whatever the case may be. I do think Shark kind of like dropped the ball a little bit with being specific in why he wanted something out. But yeah, waiting for the objection, yeah. What, why, and who's, good to see you. So lovely to wake early, because remember, what, why, and who's is, for anyone that's not in Australia, she's our friend over across the seas. So she says, so lovely to wake early in the darkness of a rainy rainforest morn and have such a groovy chat to drop into. See, the chat loves you too. Love and gratitude to one of the sweetest, smartest chicks on YouTube. Appreciate you so much. Hope the chickens are doing well. And then Chloe says, yes, this was so funny when I read it. I hope when they raid this chat, they know I'm a person and not a rehome dog. What was that one caption about, like, all my dogs? My dogs are dirty. They were insulting you, Chloe Albert. Thank you so much for the super chat. FFS says the prosecution speaks ignorance and very subjective statements. Well, it's weird because when there are times when Love will go on several sentences characterizing a 7-second video or one single post, and she doesn't even say what's in the caption, but she's busy describing what's just on the screen in the picture. Without even that, all her rambling doesn't even include the text on screen. And she'll do it confidently. She'll lay out a whole storyline, get real creative with what she has concluded this image is about. But then other times when she's asked about something, when she's asked to develop something, she's like, well, I believe. So it just like the way when there's pushback, how she suddenly has to, like, you know, hedge it a little bit is really interesting to me to watch. I don't know if you guys have noticed that. You know, just clean descriptions when she's able to speak freely on what she thinks the picture means, but as soon as she asks, it's, well, I believe that, rather than just asserting what the picture's of. So thank you so much for the food for thought. But yeah, when it comes back to it being admitted, letting the jury decide as being that excuse, and then Steele coming back with the facts and case law, when we were dealing with that Bruton argument, it was no wonder that Steele stood up. I mean, Bruton is a appellate issue. He's well-versed in appeal arguments. I think he was really clean and smooth with discussing why. And of course, his argument got shut down. It was overruled. But the idea that you can't just instruct a jury to disregard something so pointedly inculpatory that goes to the direct elements of the underlying charges, and then just hope that instructing them beforehand will make them only apply it to Yak. So great argument there from Steele. Thank you so much. And then Angie sniping with the gifted memberships here. Thanks so much, Angie. Good to see you. And Mike Ramey's already ahead, so if this cell location stuff comes in, Mike says, I'd argue that cell tracking is bunk, just like Fani did, in the same county. In the same county. Probably some of the same towers, right? So great point. And then Nancy, if you're white, you're allowed friends, it seems. Yeah. And that might be just a, you know, proximity coincidence, but maybe YSL doesn't have any white friends. But has any white person been like an unindicted co-conspirator in this? Does YSL literally have 0 white friends or white associates? Or do they, and the prosecution just looked the other way? They didn't like look to indict or treat someone as an unindicted co-conspirator that happened to not be black. Interesting to think about, because I've never gone that far, like looking at possible unindicted co-conspirators to see the makeup. But I highly doubt, you know, when it comes to clubbing and the music stuff, that there aren't people from different places that could technically be associates by some of these same definitions, these broad definitions. But where are they? Where are they? And then Leah's dad said, the judge also always knows why the state would keep something in. but fights the defense on everything. Yeah, so going back, what was that video when the guy had the snake around his neck? And they're it looks like they're in a club lounge, like maybe like a VIP lounge or something. And they're like, well, I know why I think it's relevant. Whitaker already knew. And the state was just like, do, 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 do. Cool, well, you already made the argument for us. But with the defense, it's always a fight. And I think that's where we get to that tipping of the scale. Like, you win some, you lose some, right? Judge has discretion to rule within certain bounds. But when it's constantly one side winning some and the other side constantly losing some, and the losing some can't be explained by bad arguments or no supporting case law or no basis, the lean is questionable. The lean is questionable. So great point and great observation to notice it going that way. A lot of the victories for the defense today were stipulations. So either defense said, actually, you know what, we don't actually want to bring that in. Or the state said, all right, we're not going to fight to bring that one in. They were only, going back to the social media posts from earlier, I had counted through 22, and the judge had only sustained one objection to something coming in. The rest were all the defense and state agreeing something won't come in. So there you go, just a little bit of tracking there. And then Brina says, are the defense allowed to bring up the offenses and individuals that were trying to get out by signing a plea deal? I think that's going to be interesting. I'm pretty sure it's going to be Detective Thorpe. That's going to be the one that's bringing in this information, this interview with Yak. And the defense will have to get creative in how they question and try to undermine the credibility of what Yak said in this plea. You know, since they're not able to ask Yak directly, did you understand what you were signing? Why did you sign it? Like, they can't go into this direct questioning with Yak because he's not supposed to take the stand. He's not planning to take the stand in his own defense. So they'll have to, if this comes in through Thorpe, get creative and kind of expand and ask more conceptually. Now, remember, Thorpe is the one that Woody described as peanut brain. I think he was wearing like a green satin vest over a button-down, another green button-down shirt. You know, green, right? Maybe he's affiliated with something here. But if he's, and he was the one that was talking, they were all kind of talking. But if he likes to talk and acts like he's an agreeable person, one strategy that the defense could take is just, well, you know how people say one thing and they mean another, right? That's part of your job. That's part of your line of work. All right. So sometimes when people are willing to agree to something, they're saying it for their own interests, right? Do you think Thorpe will want to look like an idiot and deny that that's something that people can and might do? If you frame your questions in ways that a person who doesn't want to just look like a dishonest person would be forthcoming about, I think the defense can walk themselves to make this exact point, that Yak could have been trying to just get out of his own trouble, and it was self-serving, the things that he said, but they may not necessarily have been true, just because they're on a piece of paper. So that one will be really interesting to watch, you guys. If you guys tune out for some of the other witnesses between the end of Woody and the next witness, I think watching Thorpe will be really interesting because of this Yak Gotti interview. So mark your calendars for whenever that may be, 4-ish weeks from now. And then Ike says, are there any photos of Steele and his client? If so, what is that? Right? Is he? Oh yeah, he's the white guy. Steele's the white guy. You guys are probably going crazy in the chat about Steele being the white guy. Steele's the unindicted co-conspirator. And remember, they've tried to insinuate, the state has tried to insinuate that Shard and Steele, who are both white, are in cahoots with all this Melnick and Kenneth Copeland stuff. Did they accuse Adams the same way? There you go. There's Young Thug's best white friend. And yeah, I had to call out I forgot I think it was a green vest over a green shirt. Like, he was all the way green, working as a detective for this one interview with Kenneth Copeland. But yeah, let the state say he's in RICO too. Anything green. Yeah, and that's true. That's true, Donald. So if you go looking for racism, you might find that, whether it's there or not, or whether it's the reason for something or not. And CJ talking about plea deal says, anybody who signs a plea deal has little input to what you're signing. It's usually amount of time you're agreeing to, details, all or no deal by the state. And I think what's important is if they're able to ask about previous plea deals in this case, just give that reminder to the jury, like, well, we can't ask Yak ourselves, but we're going to ask this guy about Yak's plea deal, and we're going to remind the jury, have them recall what happened with witnesses like Trontavious Stevens, YSL Slug, where, you know, they roped me back up for something I already did time for. Threw me in. He seemed to be unsure of the length of time, but he said like 9 months, but it was 7 months. Had me in there. It was horrible. I have my family. I have a job. I've been out of this for years. I was going to lose my job. I kept asking for a bond hearing. Couldn't get one. Multiple attorneys tried to get me a bond hearing. Couldn't get one. And then suddenly, a plea deal dropped on my desk. And one of the lines in it says I wouldn't be able to testify truthfully about the innocence or guilt of any of the co-defendants in this trial. So, and he initialed off on it. So, there you go. If you can get the jury to remember certain things like that. And that was a really fiery day. I think Keratin Matthews, I have a video on it, but maybe we can rewatch that day. We're doing some rewatches. But I think Keratin Matthews, Steele, and Shart all went bananas, like calling out this plea deal and the circumstances surrounding it for YSL Slug. Same thing. I mean, we got some interesting bits and pieces with Walter Murphy. There were a few interesting, what I would call gotchas for the defense in relation to deals that were cut for other people. And we haven't gotten to cross-examination of Kenneth Copeland. So yeah. And are we back? You know how sometimes the camera just moves, but it's not really, we're not really back. Love just like slowly trust-falled into that chair. I think there's,
Okay,
I've watched a lot of
before we
pretrial
move
stuff. I
on
think
to
a lot of
whatever
people in
we're
the
gonna
chat
move
have
on to
referenced pretrial
next,
stuff too, Lori.
Somebody kindly sent me the state 60 WA, I guess, that's already in. And I've only gotten through about half of it, but so far I don't see how the item number 14 from Zachary's folder is cumulative of what is shown in that video, and it may be in the part of the video that I haven't seen yet, but can somebody pinpoint for me? Can we pull it up and maybe y'all can tell me what part of that makes this other potential exhibit cumulative?
Hey, baby.
And I do not want to watch the whole video. I mean, I just, what's the part that the defense is contending makes Zachary's exhibit, I don't know what the exhibit number is, but the item number 14 cumulative? Yeah.
Recollection is you asked if there was another video that showed the display of handguns and quote unquote gang associated
Right.
verbiage
Right.
and things of that nature that tended to show associations with whatever we want to call YSL,
Right.
using the word slap and slime and things of that nature and displaying of handguns. And that our point was that the state has admitted, I believe this says 5 minutes long. I remembered it being longer than that, but
Oh, it's longer than that.
Oh, okay.
Because I watched it for 5 minutes.
Yeah.
The version, so the what was omitted was shorter than the original
Okay.
version.
Well, that's merciful for the jury.
Right. So, I mean, my point was, we've had these types of videos introduced before. My intention was not to suggest that it was identical or
No, and I know that,
exactly
but I
the
mean,
same.
I wasn't seeing a whole lot of like guns in the front of the camera kind of thing. And this, they're just standing around in a parking lot saying things and what have you, but
And the only portion that I believe has a gun, one of the co-conspirators, Walter Murphy, I think the line is, he just got out last night and he keep the strap on him and he lifted up his shirt, but he didn't point it at the camera. He just lifted up his
well,
shirt.
and maybe I didn't get to that part of it yet, but let me go back and look at the item we're talking about again, but it seemed much more kind of the whole point of the video, so. Sure, yeah. I mean,
My whole crew got blocked.
No, still hasn't addressed Doug's motion. Atkins looks like he's glowing. Dang, Paris River Show, we should have celebrated your anniversary 110 days ago. Dang, you've been here 100 days and we missed it.
That's why I said little D, bitch. Slide shit. Yeah, ho. Ride motherfucking playing, ho. And we have real big bullets, bitch. I don't even play with her. Yeah, ho. That's like the boy builder. Fuck they doing. So that's like the boy builder, my motherfucking big bro snake.
yeah, I'm gonna allow that in.
Yona, did you receive 2 videos or just one?
Just now of the 60 whatever?
Yeah, 60 WA, I think it was,
I
but
think
there was a second one that was sent as well that actually had.
Okay, now I've only looked at one of them.
Yeah,
How about we look at the one that was one of them redacted and one unredacted, or are there 2 different?
No, there are 2 different videos.
So one was 60 WA.
Yes.
What's the other one? Whiskey Alpha. I need to get used to that.
It was a state's exhibit. I don't know offhand
All right, hang on.
the exhibit number.
Whisper, whisper, whisper.
It's on a Google Drive. Oh, yeah, no, I'm just now getting that. So, if that went to, I mean, I guess I can pull it up, but I don't seem to be able to play the sound. So do y'all want to pull those 2 up? Because I guess they're now contending that.
Yeah, and just to kind of lay the groundwork a little bit,
Sure.
Judge, the second of the 2 videos that was sent show, it has Mr. Williams with a handgun. It has someone named Mondo. It has Buck, the person who was referenced previously,
Someone named
who has
Mondo.
a handgun displayed in the video, and it also has another person you've heard the name Fatty outside of a house. It's a shorter video, but it has the images that the court.
All right, well, let me take a look at it.
Yes.
Slide there, man. Put it on. Movement. Yeah. Just lifestyle. Oh, yeah. Real sleep, aka bleed, nigga. Yeah. Man, but mud, do this every day. Yeah. Miss like this, like kitchen, no, that. I go in the kitchen and yeah. I told him, put on the camera, we're going on the test, man. Yeah. I didn't have baby, throw it up, baby. Man, Lord, my baby, nigga. Want to give a special shout out to them. Go get some guns, my niggas, man. Watch your nose, watch your nose, nigga. Yeah. Wow, nigga. Big. Big B. Little baby rolling B. Little baby rolling B. In the fucking trench, man. Right now in the trench, keep pills. Oh, you keep them still over still, nigga. Please fucking good. Oh, not bad. Step up, you know what I mean? Nigga, real. And why fucking there? Not real slime. Why fucking there? Not real like you die by. Nigga fucking there. Get her back up. Yeah. The low top. Get her back up. Get her down like this. You have the thousand fucking years. Yeah. Hey, you're talking about everyone you fucking at, man. Right there, you niggas going in, we finna wipe your fucking nose. Straight like that. Hey, get what? At the end of the day, nigga with the camera got the pussy too. Let me grab it. Yeah, niggas, the kid thug. Hold on. Yeah. Show y'all we roll like, yeah. Yeah, we fooling, nigga. Don't get what? If you ain't slime, you're not my fucking kind, nigga. It's slime love all the fucking time. It's fucking good. Your successful lifestyle, big rep. Yeah. What you doing? Straight like that, folks.
All right. I don't find them to be cumulative, that there's one small part of that where some woman holds a gun. I don't think that that's really the same as what's shown in the item number 14. So I'm gonna stand, my ruling stands on that. I appreciate y'all sending those over there for me to consider. Okay, so are y'all ready to dive into the items that would come in with Mr. Sprinkle? Or do you want to move to something else and come back to that? That's what y'all were huddling about, I think.
Speaking for the group, I believe the preference would be to discuss the state has noticed a number of intrinsic acts.
Okay,
I think the group would like to discuss that. If
that's
it's all the
fine.
same
I
to
mean,
everyone
we got to
else.
get through all of it, so I don't really mind if we do it in a different order. Okay, let's do that. Oh, and actually, Miss Hilton, you had said you wanted to put something on the record about, I think, Mr. Huey's motion limine about I assume it was the one about the photo ID from the deceased witness. Okay, what's your announcement?
Your Honor, the state does not intend to introduce that photographic lineup
Okay.
or the interview itself. The state would ask if a photographic lineup occurred and would ask if Mr. Howland was interviewed, but not the substance of what happened with either of those items.
Okay. Does that cover it?
So, Judge, good afternoon. It does cover it, Your Honor. I am concerned on asking the question of whether or not one was occurred would make, I don't know that that would be necessarily relevant, or it kind of implies that perhaps there was one, but we're not getting into it, so I'm not sure the relevance of asking that question. Maybe the state can shed light on that.
Sure, Your Honor. I believe that we still have to show the credibility of our police officer conducting an investigation. And so I think that it'll be relevant that he conducted an investigation. That was a part of the investigation.
All right.
So, Judge,
Yeah, there's often an argument that the police didn't do a thorough investigation. They already had people targeted, and that's all this is. So to the extent that it might go to combat that, then I will admit that over the relevance objection. That I will permit that question, and the rest of it, concede should stay out.
so they're not going to ask, they'll ask that question, but they're not going to ask about whether or not there was an interview of Mr. Holloman.
Well, I think what she said she intended to ask was, did you interview him?
Yes. Did you interview him?
And whether or not there was a photographic lineup.
Are you going to ask that? I would
didn't hear
think that that's not, we should probably stay away from that.
I didn't hear it because of the mic.
Are you going to ask whether there was a photographic lineup with him, with that witness?
Initially I was, but based on what the court just said, no. Then I'll just ask, was there an interview? And then we leave it at that.
that would be the far safer route. Okay. Okay, so y'all want to move on to intrinsic acts. Okay. Which ones? Because there was a set that y'all said there just hadn't been a 403 analysis on yet. And then there was, I guess there were a few that at least somebody, Mr. Ryan was maintaining, were not really intrinsic.
Yes, yes,
Okay.
Your Honor. That's accurate. Back in 2022, the state filed a general notice that they were going to introduce intrinsic evidence. We then got a witness list on July 31st, which I think was supposed to be one of the final, we can rely upon this witness list. And within that, there were 4 incidents which happened in 2023. So they, 1, post-date that notice, 2, they post-date the indictment. So we've never received any sort of notice from the state saying we are seeking to admit this as intrinsic. However, that is what it is labeled as on the witness list. So that those 4 are what we take issue with.
Okay, got it. And these are the incidents that occurred in the jail generally?
One in the jail, 3 in the courtroom.
Okay, thanks.
I'm not sure if Ms. Abbasi realizes that we did notice 2 of the ones that occurred in the earlier part of 2023. The stabbing of the person in the jail by Mr. Ryan, Mr. Blaylock, and others, as well as the violation of the Georgia Controlled Substances Act by Mr. Williams and Mr. Adams. And those 2 occurred on January 31st, 2023 and January 18th, 2023, respectively. The filing that we noticed the defendants of those on was November 6th, 2023. There were 2 additional acts that occurred in 2023 during the time that this case has been ongoing. And one was the drugs that were found in Mr. Stillwell's cell. And we've noticed some of the pictures of the drugs and the other contraband, and the marijuana that was found in Mr. Ryan's pants when he was searched in the courtroom.
Okay, so the stabbing, that occurred in the jail, right? Okay, and then the VGCSA violation was in court?
It was.
Obviously, drugs in Mr. Stillwell's cell was in jail, right? And then the marijuana in Ryan's pants was in court. Is there another incident that occurred in court?
Not that's on here.
Okay. Ms. Abbasi, you had said 1 in jail, 3 in court.
I'm sorry, Judge. That
2 in jail, 2 in court.
Correct.
Okay. Okay. And the argument as to each is that this is not really intrinsic?
yes, Judge.
Okay.
It doesn't fall into any of the 3 categories which would classify it or qualify it as intrinsic.
Okay.
Here it is.
Let me pull out my case law on that. Which. All right. What's the state's position on why and how that is intrinsic?
The Abbasi stabbing, which is the one I'll start with, Your Honor, involved YSL.
I'm sorry, what'd you say? The what?
Oh, I'm so sorry.
I just didn't understand what you said.
Understood. The victim.
Love has been
in
so
the
soft-spoken
January
with the yeses, and I'm so
31st
sorry.
stabbing was
Okay.
Harold
All
Bussey,
right.
and that's what I
Bussey,
refer to
okay.
it as. So that stabbing involved several YSL gang members stabbing an inmate at the Fulton County Jail who was alleged to have messed with Rodalius Ryan's commissary. It involved, among others, Demise McMullen, Javon Fleetwood, Christian Eppinger, Damone Blaylock, and Rodalius Ryan. They all, in concert, held down this person and stabbed him repeatedly, all to protect and to vindicate something he had done to one of their fellow YSL gang members. It's the way that I see it. So that it seems just, it's what we've alleged in the indictment that YSL members do. They work to maintain individuals ready and willing to preserve and protect the reputation, power, and even the territory of the enterprise through the use of violence.
Okay, I understand.
With respect to the law, we would cite Johnson versus the State of Georgia Supreme Court case decided September 21st, 2021, cite 312 Georgia 481. And we cited this last week. The Penn site is 491 to 492. In support of it. Okay. With respect to the January 18th violation of the Georgia Controlled Substances Act, this is 2 YSL members on trial for conspiracy to violate the RICO Act through drug distributions, drug use, drug possessions. And while in court on trial, they are passing Percocets, one to another. And we argue one to the alleged leader of YSL while in open court. One of the assertions that we make regarding the conspiracy. We have contraband in the jail. We have stabbing in the jail of YFN Lucci. We have communications in the jail. These types of actions on the part of the defendants are the type of actions that we have alleged in the indictment, and it shows that the enterprise flows from the streets to the jail to the courtroom, and that the conspiracy is ongoing.
And what exactly is the evidence you would be introducing on this VGCSA?
The video of it.
And what all does, I mean, maybe I need
The
to,
video
what does it show?
shows Mr. Adams going up to Mr. Williams while on a break. He's appearing to dap him up, if you will. Mr. Williams puts his hand up under the table. One of our lieutenants goes over to Mr. Williams and sort of says, "Give it here." Mr. Williams brings his hand out from under the table, relinquishes the Percocet to him, and later Mr. Adams is searched. And I think more Percocet pills, more drugs are found on Mr. Adams. And the drugs, the photos and tests of those drugs.
All right. And what's next?
The marijuana was So in Mr. Stillwell's cell, there was, on March the 29th of 2023, there were drugs found in Mr. Stillwell's cell that consisted of ecstasy, pills, I think contraband, was it cell phone? A contraband cell phone, for him to have gotten those drugs into the jail while he's on trial for
Okay.
kind of actions involving narcotics and the enterprise and the sale and distribution of drugs through that enterprise. We believe is evidence of the ongoing conspiracy.
Okay.
Another,
And then the last one, I guess, was the marijuana found on Mr. Ryan. Give me a little bit more background about what your evidence is going to show on that one.
that Mr. Ryan, while sitting in court, I believe deputies may have smelled the marijuana
Okay.
on Mr. Ryan. And when they went back to try and search or to figure out where the smell was coming from, a large commotion was made. And the deputy,
A large commotion by,
Mr. Ryan, and the deputies found the marijuana attached to, I think, his inner garments.
okay.
We have the video.
Okay,
Okay.
we don't know how it got there. I mean, on the Percocet, you've got an alleged gang member providing it, right?
Yes.
So how about, we don't have anything like that with regard to the marijuana?
We don't have
We
who
just-
provided him with the marijuana, no.
Okay, all right.
I don't know how pertinent it is that we have one that's not on here that is also involving drugs that are brought into the courtroom and provided to another YSL member, but that particular one has been severed, so we don't have that one
Right.
on here.
Okay.
Right.
I think that the first three that we talked about are, I can see how those would be intrinsic to showing the allegations that, this is a continuing, ongoing RICO enterprise. Mr. Ryan being in possession of marijuana when we don't know where it came from, that one, I just don't see that falling within. I mean, it shows, what it shows, that he's in possession of an illegal substance, but it doesn't, I don't think it's intrinsic. So I'm gonna rule that one out.
Yes, Your Honor.
The other three,
Your Honor,
yes. Go ahead.
I appreciate the directed verdict that you just gave for one of Mr. Ryan's.
Oh, is that
intrinsics.
one of his, that's not something.
No,
that-
no, I'm saying,
Yeah.
I'm saying you're
That's
keeping
not
it out
anything
without
that-
hearing, but from us, but, regarding Mr. Stillwell's.
Mhm.
Okay. We have an indictment with 100, I believe it's 191, could be off, 191 over X.
Yep.
Okay, we also now have a list. At first we thought maybe they had abandoned these 53 and they were narrowing it down to 4, but no. It's 53 plus 4,
Yeah.
57 plus 191. That's 248, I believe. 248 uncharged events, or not substantively charged
Right.
events in that are coming into this trial. Regarding, the state keeps saying, and this shows the enterprise. Okay, there were apparently, I've seen photos, I wasn't there. There were pills that were recovered from Mr. Stillwell's cell, where he has a cellmate.
Okay.
Okay. There is absolutely nothing about those pills that suggest they were provided by anyone associated with YSL. There's absolutely nothing that suggests that those pills were going to anyone associated with YSL. There's absolutely nothing to suggest that any proceeds from those pills were being provided to anyone in YSL. There was a phone. I have not received any information from that phone that suggests any link at all to YSL. I am not saying my client's a drug dealer, but what I am saying is people that are in possession of drugs, whether it be my client or his cellmate or someone else, are able to sell drugs without being part of a huge enterprise and without any evidence that somehow this is linked to YSL. This isn't intrinsic. The test for intrinsic is an uncharged offense arising out of the same transaction as the charged offenses. I don't believe that's the case. Evidence necessary to complete a story of the crime. That is definitely not the case in this scenario. And it's inextricably intertwined with the evidence for the charged offense. I don't believe that's the case either. So
I wish he led with
don't know
this.
why
I wish he
this
started
is-
with it.
Thank
and
you
he
for,
is, and just so you know, Your Honor, he is charged on a separate indictment. I believe it's indicted. If not, it's in a CP case still, but he is charged separately. And that case is pending in Fulton County Superior Court.
okay, appreciate it. Thank you for bringing my attention to that.
Your Honor,
Yeah.
if I may a bit further, the one case,
On which?
really regarding all three of them. I'll
Okay.
start specifically with the stabbing as the state did.
Can I rule on this other one first? Give me just a second.
Which other one?
The one that Mr. Sharp was
Stillwell.
just
Yes, Your
talking
Honor.
about. Okay. So the Stillwell had a cellmate. Is there any evidence as to where the drugs came from, or that it was his, or that the cell phone was his, or connected in any way to YSL?
Well, two things. So yes, we believe that, I think we have, do we have body cam research? We believe that the testimony from the deputies within the jail would establish his ownership of it, but more importantly, what we have, I briefly touched on it, was the other YSL member whose intrinsic act that we've not put in here. The pills, if we call them purple hearts, blue stars, and yellow diamonds, they were trafficking amounts in Mr. Stillwell's possession, and they were trafficking amounts in the other YSL members' possession. That is not on here and that has been severed. They are the same type of pills, and they are a large trafficking amount.
Okay, but
And we know that at least that other one, that other YSL member smuggled the drugs into the jail, or at least into that area, through the courtroom. As it was described, it was enough in one, it was a pharmaceutical.
okay, so any evidence that what was in Mr. Stillwell's cell came from that?
Other than it was that they were just alike. If you looked at photographs of it's not like you had all white pills. Like you had the same array,
Blue,
variety,
purple, and
to use just some colors. Like they were literally at least three different colors and three different shapes of pills. And they were the same, three different colors and three different shapes.
and you can establish that those were YSL related?
Yes, because, yes,
How?
when you say those, you're talking about the one.
So
that
if
originally came in?
I'm to accept that y'all have enough that you can make the assertion that the pills that came through some court proceeding to this other person who's not a part of this trial,
Right.
are the same that are in Mr. Stillwell's cell, then what's the YSL connection?
Not the
there?
same pills, the same.
Type, the
Yes.
same, shipment or whatever, the same.
That person was in this trial. That person was in this trial during that time.
Okay, but them being in the trial and co-defendants doesn't establish what the assertions are.
No, it's the it's not similarities, the exactness of the, like,
No, I'm not asking at this point, like, assuming for the sake of argument that, yeah, these pills all came from the same place. And he, in fact, then what's the YSL tie-in?
may we approach with a member of the defense?
Sure.
Are we approaching? Look at them talking. Look at them talking. Hilton looks like she's like, why would you do that?
I didn't know y'all didn't have them. They're not up here. Yes, you may.
Thank you.
So are y'all satisfied about, our other bench conference was about the location of that other person? Everybody, I just assumed that y'all.
Okay, are they muting? We're not quite at the bench yet. Love is still trying to figure out her argument. Look at Hilton. Hilton looks annoyed. Oh my god, this is your bench conference. And you're the one that hasn't approached. Look at Doug looking over. Yeah, it is like a doo-doo-doo type of moment. So they'll still do like bench conferences to keep it off the media. Maybe it's private information or who knows what. Maybe it's just an argument that Love doesn't want on camera. And then Gil had said earlier, judge always leads the state. Will you use it for recollection or for impeachment? Which Love repeats. Love just echoes back what the assist from Whitaker seems to be. Let them answer for themselves on objections. To be fair, if you want this trial to move along, you might need to give Love the assist. The downside, right, if we don't let Judge Whitaker give the assist, we might just have Love buffering indefinitely for minutes, hours at a time. But it does seem like, especially today with pretty much really any of those social media posts, and some of the stuff with the Yak statements, the Yak interview, Love was just on pause. The judge looked over and was like, well, what are you going to say? Are you going to say this or that? So you're exactly right, Gil. But yeah, the other side, the alternative would be just to let Love stand there and try to think of something. So you got to pick your battle. But it does seem unfair because the assist isn't happening in the same direction for the defense. And that's not to say the defense doesn't know an argument that they want to make, but sometimes when Shart starts talking about things that are more theoretical and descriptive and doesn't jump right to the basis or to the law, the thing that Whitaker seems to want to hear, it would be nice if she at least tried to assist and cue them the same way she cues the state. She could balance that out a little bit, but she doesn't. Thank you for the super chat. Same thing, Nika. Thank you for the super chat. And then Chloe Albert's Revenge says that by Love's standard,
Right,
her
and
Avon
with
lady's in a
regard to
gang.
the Contraband in Mr. Stillwell's cell, I'm going to rule that out as well.
Okay, nice win for
we may have another
Shart.
indictment against him at some point in time, and it would all be appropriate to come in there, but not for this case. So that now, Ms. Abbasi, what do you want to say with regard to the other two?
Yes, Your Honor. Your Honor, actually, the state cited when they discussed the stabbing, the same case I cited, Brown, which had, as Mr. Shard said, those three circumstances. Uncharged offense, which arose from the same transaction or series of transactions as the charged offense. That's actually the topic of discussion in Brown. And in Brown, it was a robbery which happened 1 hour before the charged crime. If the state is going with it's part of the same transaction or series of transactions, then we have a very serious problem with proximity, because the case law is not anything a conspiracy does that happens over the lifetime of the conspiracy qualifies as intrinsic, it has to be closely linked with the others, closely linked with the other charged offenses within the indictment. Your Honor can look at Sanchez Villa versus State, just 341 Georgia App 264 from 2017. Within that case, the evidence the state was trying to present, the court found all of the cases the state submitted distinguishable. And the same is true here when Your Honor goes through the cases as far as being part of the same transaction or series of transaction as the charged offenses. This, like those cases, is attenuated in time. For ones which do have more time in between, they discuss how in those cases, the defendants in their other uncharged acts were in the exact same role. So in one, it was trafficking cocaine as the lookout. In the uncharged, trafficking cocaine as the lookout. There were very specifics linking them.
Were any of these in the Sanchez Villa, either those facts or the cases that are distinguished, either a RICO charge that was involved or a gang enterprise?
I will double check because they go through quite a few cases. I'm going to have to look back through all of them. I think the hallmark of it that we get within Sanchez after they discuss all these cases, the evidence in this case, the Sanchez case, is considerably more attenuated in time and space from the events leading up to the charge offense. So it offers little to help the state. They continue on and say that, well, as far as this goes, we're not in a circumstance of completing the story of the crime. This is just expanding it.
Yeah,
completely.
I mean, right, it's a different crime, but it might have been a different thing if they were charged with a RICO count in Sanchez. So that to me is what, if these were just whatever the other charges in the indictment are, then I would say, no, but it's the kind of enterprise nature and the ongoing nature that.
And I certainly understand that, Your Honor. I think, however, to say, well, it's part of the conspiracy basically opens the door to anything any defendant allegedly who is a member of YSL does, then automatically becomes part of the conspiracy and automatically comes in simply because it is intrinsic. I think with a lot of this, Your Honor, we're getting close to some due process concerns here. The defendants are on trial for the offenses they were indicted of. That's what they're on trial for. They're not in trial for the enterprise continuing in 2023, that it was still ongoing. That's just not relevant. If the day after indictment, every one of the defendants got together and said, whatever our group is over, and it was completely disbanded and no longer continued to exist, that wouldn't be relevant either. What they're indicted for is what they're on trial for. So here we're expanding. That's, I think, a lot of what's happening with our social media and other things that I guess the state has found afterwards. They're now being tried for things the grand jury never heard about. And that specifically is a violation of due process. I can supply to Your Honor the U.S. Supreme Court case law.
No, I'm with you on that one. And I am very skeptical of the state's argument that any uncharged, not showing up in the indictment overt act that they offer could in any way support, if found, a RICO count being
I wish we could see the
established.
state
So
right now. I wish we could see their
unless I hear
face.
otherwise, which I don't want to hear otherwise right now. We'll take that up another day, but that's not our issue right now. But yeah, I think the state's got some convincing on that count. But with regard to whether, it's intrinsic, I want to get it right. I want to follow what the law says about it. So I think that the key issue here is if we're talking about RICO or we're talking about, a gang enterprise kind of thing. So maybe we could all do a little bit more research on that.
I did look at, in the state's original notice, they cited a proposition, I believe that was cases have been in gang and conspiracy prosecutions. Gang and conspiratorial activities have been classified as intrinsic evidence. They then cited a number of other cases. There is not one single case I can find in any case at all where the intrinsic actions come after the indictment, because that's the touchstone of it being intrinsic, that it really is all one thing, that the story doesn't make sense without all of these pieces. And these things hadn't even happened yet. So
Yeah.
it's not possible
Let-
that they could be essential.
Let me ask you this. If, for instance, and this is entirely a hypothetical,
Yes.
but if this group got together and stabbed this, whatever his name is, Abbasi, not because he messed with Mr. Ryan's commissary account, but because he was going to be a key witness in this case. And I'm sure the state, if in this hypothetical, would argue we're trying to send a message that he better not be a key witness in this case. Would the argument be different then?
Well, yes, it wouldn't be, they wouldn't be trying to admit it as an intrinsic act. It could be a crime in and of itself separately.
No, we're not talking about then they get separately indicted. We're talking about they're in the middle of this trial. This happens. It's not obviously set forth in the indictment because it just happened.
It would be 404B and probably fall into a category there, which would make it admissible for a basis which was not character. It just wouldn't come in as under intrinsic.
Okay, so you would still make the same argument that that it couldn't be intrinsic evidence, even for that, because it occurred afterwards.
Based on the definition I've seen of intrinsic, I don't think it's possible for something which comes after to be necessary to complete the story, unless the story wasn't complete at the time of indictment. But that's fundamentally unfair to try them for something which hasn't happened yet.
Okay, they're not being tried for it.
Correct.
But okay.
Based on your
All right,
example.
well, I mean, y'all try to find me some more on point law on both sides, please, if you could. So maybe that'll be my preliminary ruling, subject to revisiting, okay?
And Judge, there was one other thing. I don't know that it'll have any bearing on the court's ruling, but in that instance where where the drugs were found in Mr. Stillwell's cell, there were, Miss Hilton pulled up the photograph that I asked her to, and there was a shank.
Is the shank inscribed YSL? Then it doesn't,
no.
I mean, it makes Mr. Stillwell look bad, but it's not intrinsic.
Yes.
Okay.
Your Honor,
Yes.
if I may,
Yes.
before you make a decision on the one alleged intrinsic act that was referenced by the state involving the supposed passing of a Percocet pill from Mr. Khalif Adams to Mr. Williams, I would ask that the court
Clarify
at
the
least
other
go and
Adams.
take a look at the video that was referenced by the state. I think it's instructive. I also think that well, fortunately for us, paints a different picture than was recited by Madam Prosecutor. I think the events did not occur in the manner that she referenced. I was present. I was sitting right next to Mr. Williams. I think the video will show something being passed to Mr. Williams, not him hiding his hand underneath the table or bringing it out and then giving it to the deputy, or the deputy saying, give it here. It didn't happen that way. And I think that goes into the analysis of exactly what happened.
All right, why don't you just tell me what you recall or what you think the video shows?
Sure. What I recall and what I know happened, because I was sitting right next to Mr. Williams in the front of the courtroom, is that there was a break. Mr. Adams, who was sitting in the rear part of the courtroom, came up, and as he was going towards that door, goes as though he's going to give Mr. Williams a high five or a dap or something like that, and put something in his hand. There's a deputy who's standing about 2 feet in front of Mr. Williams. Mr. Williams looks surprised. Mr. Williams has it in his hand and puts it down on the table immediately. There is no putting hand under the table to try and conceal it. The deputy, who I was within earshot of, did not say, give it here. Mr. Williams looks at it and puts it down on the table, and that's it. And at which point another deputy sees Mr. Adams and either takes him, I don't remember if they took him in the back or brought him back here. He was searched in the back, as I understand it. I think court recessed after that because of those occurrences, but that's how the incident actually occurred.
Okay. Can y'all send me that video?
Yes, and the deputy, the lieutenant, would also be a witness. to what I'm saying.
All right, well, I mean,
The version
I would
I'm
imagine the video shows what happened, so.
It does.
It does indeed. Speak for
All right,
itself.
well, we'll come back to those two. All right, so that takes care of the allegedly intrinsic, but according to the defense, can't be intrinsic because they happen later in time than the indictment acts. What about the other intrinsic or allegedly intrinsic acts that there has not been a 403 analysis on yet?
Can I just add something to the last? Your Honor, can you ask what the prosecutorial need for this is?
I can, but with intrinsic acts, that's not part of the analysis.
Yes, 403 is the
Well,
analysis.
403.
You need a balancing act.
Which
So-
Yes,
includes
you do.
prosecutorial need, waste of time, prejudice, substantial prejudice outweighs any probative value. But to me, this is a big case. It's
It
been going on a
is.
long time, and now intrinsic acts. So yes,
Okay.
I don't know how much the state needs to prove that Mr. Williams was knowingly or unknowingly given an alleged item. I'm not so sure the crime lab came back, but I can't answer for that.
Has the crime lab come back?
That may be true. I don't know. I don't remember.
Okay. All right, so we now have a 403 argument or objection.
So, Your Honor, I think that the court had it right regarding the need to analyze, looking at the prosecutorial need. If it's a 404B act, then that would be a situation where we would be looking at the prosecutorial need, but it's not. We're alleging that it's an intrinsic act. And looking at 403, Your Honor, the analysis is it substantially more prejudicial than probative? And it's simply not, is our position. He's alleged to have, Mr. Williams and the other indictees here are alleged to have conducted drug transactions. One of the acts on the indictment involves
Them having a trafficking amount of drugs, right?
at least one. So we would argue that it in no way can be viewed as substantially more prejudicial than probative, and it's intrinsic. But we're pulling up the video too.
Well, I mean, I guess is that intrinsic is yet to be determined based on the time period, but
Your Honor, this is
Yes.
not really my argument, but I have got to weigh in here
Oh,
on
please
this
do.
issue. Yeah, thank you.
Go, Doug.
I'll get my 5 minutes in. The 403 analysis is not limited, as you know, to is it more prejudicial than probative? As Mr. Steele said, you also have undue delay and waste of time, and those are factors
It's
as
like my
well
motion.
that I'm not surprised that the state ignores, because they seem to have no concern for delay or waste of time. So those are factors that the court should consider as well, Your Honor.
all right. Thank you. Okay, well, I will
He
give y'all
pressure
a
cooked
couple of
there.
days to, if you can find more on point law, provide that. And if not, I'll just have to go on what we've got and make a decision. I'll take a look at the case that got cited and the cases within that. And then if need be, do the 403 analysis. I may not get to that, but okay. So that's those. What about the other intrinsic acts that 403 hasn't been done on yet? Do y'all just, is there a list? And is it? And I can't, let me see who, I'm not sure quite who filed that one. Or maybe Mr. Short just told me there are some that the 403 hasn't been done on yet. From the November 6, 2023 filing, but I don't know which of those.
And some of them have already been, so the Judge Granville made an initial ruling
Right.
on one day on 1 through 3. And then throughout the trial, we dealt with and admitted evidence on number 4.
So now
Is
Glanville's
not
ruling
right
should
in front of me.
stand.
List you're referring to.
The
Is it-
filing on November the 6th, 2023.
Yeah, I think
Of
I've
the-
got that. Give me a second to locate it.
And thank you to Good Vibes and for always, forever, for life for becoming members. Glad to see you in green.
Okay, yep, I've got it.
So, Your Honor, my recollection is that we began discussions on this one day a long time ago.
Okay.
And I agree with the state that they have presented evidence on some of these incidents, some of these acts. Your Honor is saying that we haven't done a 403 analysis. I don't believe
Only
we've done.
because y'all, that's what I thought you had said to me.
Okay, if I said that, I believe I misspoke. I don't believe
Okay.
we've done really any analysis on this list. Meaning,
Okay.
I don't believe, speaking for the people on this side of the room, I don't believe that we are conceding that they're intrinsic.
All
and
right, so
getting
we
to
may
the
need
403.
to, starting with number 5, look at all of them.
Like, Your Honor, I thought we were going by the state's July 31st witness list. So that would not encompass all of these things on here. That witness list went through by what offenses it was set to
Oh,
prove or
this one?
acts. Yes. So I was relying on the witness list when filing motions in limine of what they actually intend to prove. I thought that was the whole purpose of.
Well,
Judge, I'm not sure if Ms. Abbasi, we filed this November
Yeah.
the 6th of 2023, and I know she wasn't here at that time, but we, this is the argument I think that Mr. Sharp made. This is the one that he sent out with his objections. This is the filing. So this is the one that we're addressing.
okay, well, I mean, if for instance, you're not gonna, you don't intend to use, 20 through 30 anymore, tell us that. If you still think you intend to use every one of them, tell us that.
A lot of them have already been completed, and there have
Okay.
been testimony, there's already been
All right.
testimony on a lot of them.
Okay, so can you tell me right now?
Yes.
Which that's true for?
Number 4, the 5/12/2013 aggravated assault in home.
Yeah, I mean, I've got it right in front of me, so if you just want to say number 4, that's
Number-
fine.
Number 4, number 5,
And you said a ruling had already been made on 1, 2, and 3?
yes.
Okay.
We didn't admit them, but they were. Okay, so we did not admit evidence of 1, 2, and 3. All that we did was address them initially. We didn't admit evidence, and we don't intend to, but those are the only 3 that were addressed initially.
And you don't intend to, so you're not intending to introduce those 3?
Right.
Okay, well then we'll cross 1 through 3 off the list. Okay, 4 has already been admitted, 5 you said's already been admitted.
Right.
Now what?
Also, as it relates to 7 is one of the overt acts listed. The reason that we included it here is that Shannon Stillwell's name was not in the indictment itself
Okay,
on that overt act. The same as to number 8. What? I said the same as to number 8.
okay, so those are listed, those acts are listed as overt acts, but Mr. Stillwell is not listed in the indictment when
Right.
you're talking about the overt acts. Okay,
Correct.
all right. What about 6?
6, actually, we so 6 is going to be talked about. It has already been talked about
I thought so.
some, and it'll be talked about some more.
Yeah, I thought it had already been talked about some. So I mean, that's in the past, basically. 7 and 8, given that they're overt acts. adding Mr. Stillwell to them, that can still come in as intrinsic. What else?
10 has already
How about
been,
9?
9 has not been talked about.
And do you intend to still present evidence of that? I mean, you do at some point need to streamline your case.
So we can strike off number 9.
All right.
I believe. Ten and 11 have already been alluded to, and in fact, 11 has been discussed by the witness who's currently on
Okay,
the
so
stand.
those are already in.
Yes, and I think that the court at first asked me to tell the court which ones that we had
Well,
already.
you know what? Why don't we just walk through them the way we're doing now? Because you might decide on some other ones that you don't need those.
All right, so Hill Street there will be testimony given on that through Detective Dennis.
Okay. And
Oh,
his.
he already
involved in
talked
that.
about it, Ms. Hilton has
Okay,
reminded
so
me.
that's already in also. Okay.
Number 13, a witness has already talked about,
Okay.
Mr. Copeland on the stand. Number 14 has already been testified about.
Okay.
We've taken off number 15.
Okay.
Number 16 has already been testified about. Number 17 has, we've already presented evidence on.
Okay.
Number 18, we've already presented evidence on. Number 19, we intend to present evidence on.
All right. And tell me, is that like part of the gang rivalry leading up to Mr. Thomas's? I mean, I'm just looking at the date for that, or why is that intrinsic? Why is that a part of the whole story?
Already.
We've talked about it, or y'all have talked about it.
She's right. We did.
I'm not aware in
The aggravated assault at Trestle Tree on the 8th.
what case is that?
The aggravated assault at Confederate Court,
I'm aware of that, but
through Detective Dennis. I believe that when he gave, I'll have to go back and make sure, looking at our, at the flip chart that we made while he was on the stand.
Okay. But would this be part of the back and forth that y'all assert led up to?
It was part of the shootings that they went back after the murder of Donovan Thomas and found out about. So that when we say back and forth that led up to it, they started investigating those shootings after the murder of Donovan Thomas.
Okay.
And this was one of the ones that
And this is a shooting of whom by whom?
at Trestle Tree, which would have been if gang territory, we allege by YSL members. But
Okay, and what evidence do you have of that?
we did. Okay. So, and just so that Mr. Sharp has that, it's for 150080094. We've already put the CAD report and the 911 call in.
okay.
Okay, well, that pretty much
Well-
sounds like that's in then.
Well, I don't
Okay.
agree. I mean, what's I think obvious right now is I've been very involved in this case.
Mhm.
I don't know what this January 8th shooting is. I'm asking Miss Love. She doesn't know. So I'm trying to figure out how anyone could argue, if no one even knows what it is, how it's so intrinsic to this case.
Yeah, I don't know if she doesn't know what it is.
Well, I mean,
period,
I keep
or if
asking,
she
I'm
just
giving
doesn't
a-
know right now what it was. So who is alleged to have done this?
So
Or is this just a general, we, the gang experts, found out about this and we think this was a part of it? It's so, okay. Is there gonna be more besides what's already been
no,
testified to?
No.
Okay, so it's already in. Okay.
Okay.
number, what number?
20.
20. We have already heard testimony on this one.
And that's all we're gonna hear as to that?
Yes.
Okay.
Yes. And we've already heard testimony on 21
All right.
and 22.
Mhm.
We're not introducing 23.
Okay.
24, we've already heard testimony about, and we will hear more. This is actually where we got that video from that we mentioned. Mr. Sledge, that's in the folder for Mr. Sledge.
Mhm.
Number,
So, hang on. What else is gonna come? I mean, great if the video happened to be from there, but what else is gonna come in about this ag assault criminal damage?
well, Antrevia Smith is one of the witnesses that we've listed,
Mhm.
and her testimony.
That's a victim?
Yes, that's whose
Okay.
house it was.
All right. Okay. Go ahead then. 25.
This is January the 28th.
And then Delicates of Life, I'm not sure who Nikki Barnes is. So I missed the context of your comment.
I thought we'd already.
So back to the blue magic in the pills.
Kendrick.
But I didn't know who Nikki Barnes is by name.
$15.02.
There we go. There we go. Thank you.
Back to 25, 20.
Okay. That's fine.
26,
Oh, another movie for my list, you guys.
introduced evidence of 27, we've already introduced evidence of 28, we've already introduced evidence of, with the exception.
And FFS says we're running on.
Hilton is reminding me that with the exception of Shannon Stillwell's involvement in the Little Wayne bus shooting, it has come in, but it was added here because Shannon Stillwell's name was not on the overt.
All right, that's fine.
That love is running on Windows XP with dial-up.
29 is coming up. The shooting at Club Crucial preceded the shooting at Adele Drive and Drew Drive, and that's duplicative of 7 and 8. So 30 through 33 are the same.
So, I'm sorry, 30 through 33.
Yes, I was saying 7 and 8 if the court would just.
Oh, okay. So they're just listed on here twice, basically.
Yes.
Okay.
34 is already.
So I can just cross off 30 through 33, right? Because we've already covered them. Okay.
34 has already been testified about.
Hey, did the prosecutors have to do their training this morning?
Okay.
Was that why they were late?
36, we don't, well, actually. I asked the court to allow us to come back to 36. I believe that there are ruling may have been made on that.
Okay.
At first,
Right.
I want to check. and make sure. 37's already been testified 39, we don't intend to introduce evidence of.
Okay.
40, we do intend to introduce evidence of.
Okay. That seems pretty intrinsic.
We were taking off 41, Mr. Linder has been set. Oh, Judge, I
Yeah.
apologize. As far as 39 comes in, I was thinking of another incident. 39 is coming in. That is what led to the arrest by of Mr. Kendrick and Mr. Arnold with the firearms that Mr. Kendrick entered a guilty plea to that involved his plea colloquy that we spoke about earlier. But the fact that Mr. Arnold didn't want to identify Mr. Curtis or testify against him at trial is not, we're not putting that part in.
Okay, but that Arnold was assaulted by
By
that
Marquez.
you want to have come in? Is that what you're
Yes,
saying?
yes, yes. That is what led up to the arrest of Mr. Kendrick and Mr. Arnold. They went to retaliate. So my apologies. That's 39 and 40 coming in. 41 being taken out. 42, we don't intend to introduce evidence of 42.
Okay.
43, we do intend. 43 is coming in. Well, we intend to introduce evidence of 43. That's tied to the armed robbery that he's alleged in the indictment to have committed
Okay.
on October the 11th. 44 comes in because that, we believe, is the motive for the murder. That is the last murder on our indictment.
Okay.
45 similarly is tied to the Shamel Drinks murder. So we would argue and would ask that that be allowed to come in. 46 as well is tied to the murder of Shamel Drinks. As a matter of fact, 47 and 48 and 49 are all tied to that murder. So the ones that we've listed as intrinsic that the court has heard us talk about, for the most part, 90% of them, I think, are part and parcel of acts that have been alleged in the indictment that just didn't include certain aspects that are now listed on this supplement.
All right. Yeah, I mean, there's not a whole lot. Well, what about 50 and 51? Those are the ones that we just talked about. Okay. All right. So other than those two, I mean, honestly, most of it already has come in, or is like, I don't think even arguably not intrinsic to the rest of the crimes and overt acts. So I think the rest of these, not 50 and 51, but the rest of them, unless you've got some kind of a 403 argument to make, those seem appropriately in. Okay, so sounds like that settles that.
Yeah, I was gonna say,
other
no
than those two
objection.
Subsequent acts.
And Peter Ortiz, I thought you looked familiar. Moderator over on Professor Nez's channel. I love your channel. It's interesting and informative. Thank you so much. And I can imagine it was probably a whirlwind holding it down. That was a big interview the other day. If you guys didn't see the Ashley Merchant interview, it's got 146K views right now. Here is the link to that. But good to see you over on this side, Peter. I'm glad you're hanging out with us.
All right, with regard to the, I think I already asked y'all to do this, but the Bruton portions of Mr. Kendrick's statement, y'all are gonna try to get together on that, or have y'all already done that?
I thought it was agreed that because I listed out what I believe are redacted portions, and I gave the timestamp on the actual interrogation, then the state can say we disagree or we agree, we could get together.
Okay, but that hadn't been done yet. Y'all still need to do that?
Right.
Okay, well, that's something I think we might
That
get
was
to
filed Friday.
tomorrow.
That was filed on Friday by
As
Steele.
We were just served by Mr. Williams a bucket of exhibits. I think he wants to introduce with somebody at some time
Okay,
through a Dropbox link. So we could probably discuss those this week as well.
okay.
We can, but it'll take about 8 seconds. There's not much to discuss. I added a video and I specifically wrote what it is, and then I added it to the Dropbox so everybody has the world that Mr. Williams may introduce at trial.
Okay,
Exhibits. So it's just one video.
all right.
But it's a bucket? Guys, you guys called it so quickly.
So do you
How is this a
believe,
bucket?
the state will be able to examine whatever
Woe is me.
portions of Mr. Kendrick's statements they think might need to be redacted and let us know?
Guys know what it's time for?
Okay.
Some of the, I don't agree with them, but I can look at them and have some agreements that they're arguing by tomorrow.
Okay, sounds
60-second all caps vent.
So tomorrow we'll still need to do that. We'll need to do the PowerPoint.
We served that one.
Right. So I'd like to maybe take that up tomorrow or sometime this week. I want us to be ready on as much as possible though, so that if we finish one topic, we can move on to the next one. And then we've still got I guess after those two, we just keep moving through the evidence that are in the first 60 witnesses and, figure out any kind of rulings that can be made ahead of time as to those. And that would include Mr. Sprinkles. Okay. And have y'all done the next 30 yet?
They had everything until 60, and we'll work on the 61
Through 90?
through 90.
Okay.
Your Honor, just
Mm-hmm.
calling this to your attention. Ms. Hilton is correct. She identified specific co-conspirator statements or things that they allege are co-conspirator
Right.
statements. In reality, we have a lot of different voices here.
Mm-hmm.
I have reviewed all of the wiretap calls
Yeah.
that are relevant, at least.
Okay.
But in my opinion, there's going to be no way to litigate those matters other than just going through them. I hate to say that, but we're not going to agree that any of them are in furtherance of a conspiracy, and we're not going to agree that a number of them, we don't even know who Mr. Garlington is talking to.
Okay.
So that is something that I would humbly suggest should be on the agenda, because we're going to have to work through that.
Okay, yeah, I agree. This is the wiretap. We got to get through all of it. So what witness is that going to come in through?
Your Honor, that's going to come a little later in the trial through Investigator Viverito. So this will be probably towards the end when we're talking about the Shamel Drinks murder.
Viverito?
Yes, Your Honor.
Okay, well, if we get through, I mean, it's a big chunk of stuff we have to do outside of the presence of the jury. So it may not be what is first on tap, but we're going to try to utilize our time. So that's something we need to turn to as well.
And to give just a quarter reference, it would be after witness 91. And this is when Investigator Viverito comes up, probably her third or fourth time. So
Okay. Have y'all
And then,
given
guys-
thought to streamlining your witness list and your evidence?
So Judge, just so that the court is aware, early on, I don't know how familiar the court is with the number of witnesses that we initially started out with, but we started out with over 700. And before, I believe, Mr. Weinstein filed his first motion to limit the state's case with the former trial judge, the state announced to defense that not only would we actually be asking for an earlier start time and a later finish time, but we actually told them that we had reduced our list from the over 700 to just over 200. And we've reduced it further. And then after that was when I believe Mr. Kendrick filed a motion to force the state to reduce its list, but we had already said and done that. So now we've reduced it even further. And I believe that we are at that point where we've reduced it. The delay that Mr. Kendrick referenced in his motion has not been attributable to the state. We have had a number of administrative days. We have had a number of delays that were caused for other reasons that had nothing to do with anything that the state's case entailed. So our case and the length of our witnesses is not prolonging this trial at all. And our position is that we have streamlined it considerably. We continue to streamline it even after our first.
This argument is
we
taking
apprised them of.
forever.
All right. Well, all I'm saying is, please try to do what you just said you are doing, which is continue to streamline, and I don't have the entirety of who's saying what to what, but you do have the thing that says what counts each witness is going to go to. Just make sure that you're not being cumulative and that the witnesses you're calling are basically worth calling, that they're going to add something material to the jury's ability to decide this case.
And Your Honor, we have indeed been doing that. I think that the main cumulative objection has come from, as I remember, they've argued, well, they've called a gang expert, 3 gang experts, and that's cumulative. But each gang expert has talked about a different set of information that they have knowledge of. And they also had factual information that they were both fact witnesses and expert witnesses.
But you're expecting 2 more gang experts?
In terms of new ones? There were 2 left on the list that we haven't yet gotten to.
Right, so
one of them we may not call.
Okay, well, you would need to be able to express what it is that expert or those 2 experts is going to offer that hasn't already been covered by the 3 that have already testified.
We would.
Okay.
And Your Honor, I would like the opportunity at some point this week, I expect the state to respond to the motion that we filed, but I would like the opportunity to actually argue that in front of you.
Well, I mean, I don't know that I need a response from the state. I also don't need argument from you. I mean, I understand what you're asserting in your motion.
I mean, just today, Your Honor, they say that gang experts, for example, because that is one that we have gone to, that they have not been repetitive. But just today, and I wrote this down because it's just emblematic. Just today, Ms. Love said, quote, our gang experts have testified to B replacing C. So here, there's a situation there where their gang experts have testified to the same thing multiple times. There's B replacing
Yeah.
C. It's constant, Your Honor. And there's absolutely no reason that they should get to run this courtroom. Now, I'm not asking to run it. I'm asking you to run it.
I'm running it.
Okay? And you have the ability to put a time clock on the state. We're way past the time. I'm just going to finish real quick. We're way past the amount of time that we have told the jurors that they will be here. And that is a factor that you can consider.
3
We
to
told
6
the
months.
jurors, now I remember 6 months. Other people have said we told the jurors 6 to 9 months. We're going to far exceed that. There's any number of reasons, and they're outlined in the motion. If you don't want me to argue it, I won't argue it, that we can put a limit on the stay, or you can put a limit on the stay.
Okay, I understand what is set forth in your motion. I understand the law. I understand what my powers are as the judge presiding over this case. I understand that cumulative evidence is unnecessary and maybe undue delay and a waste of time. I also understand that the state has a right to present its case and that they don't have to be limited to just one witness per, count in the indictment. They have rights to. So I appreciate what you put forth there. I agree with it. I mean, it is granted. Okay. I will not permit there to be excessive, repetitive witness after witness saying the same thing, exhibit after exhibit showing the same thing.
Well, the relief I requested was to put a specific time, whether it be days or hours or however you want to do
Okay.
it. So if that's granted, I am thrilled.
Well, I'm not sure that I know at this stage, given that we have only not yet gotten through one incredibly long and somewhat painful witness testimony, what that time limit might be. I don't anticipate most of the other witnesses to be as long on the stand as this particular witness has been.
Hope
And
Zachary
maybe
or
I can
Sledge
get-
also try to plead the fifth
maybe
or something.
Let's just ask the state right now, like time-wise, do y'all expect any of your other witnesses to take as long as Mr. Copeland has thus far taken?
No, we didn't expect him to take them.
But Your Honor, this is not the only witness that is
I
taking this
cannot do
long.
anything about what happened before I was the judge.
I appreciate that.
I just can't.
And I'm not asking you to. All I'm saying is that the state's saying that they don't expect other witnesses to take this
Give
long.
them a constraint
There
so they
have
can
been repeated witnesses that
micromanage
have
themselves.
taken weeks.
Okay, well,
And I mean,
let me drill down a little bit more, okay? So are there any other witnesses that are gonna have video interviews that are anywhere as near as this witness?
No, and
Okay.
for any witnesses that have taken more than a few days, there have been breaks, there have been pauses that have caused us to have to take that witness over a period of time longer than we ever anticipated.
And I hope we don't continue to have sound issues, but nobody can do anything about that, although I'm trying to at least get us a reasonable backup, which should have already been in place anyway, but all right, so I'm going to need an answer as to why there needs to be any other gang expert at all in some amount of detail. And y'all have the witness list, just like, you have the state's witness list. So if there's somebody else like the 2 extra gang experts that you all looking at the list and knowing the case backwards and forwards think, the person who's going to say this, somebody else already testified to all of these same things, then y'all bring it to my attention and we can go through and get answers as to whether those people or those witnesses or those exhibits are cumulative. But I can't know at this point in time. I haven't been in this case long enough yet to see what's reasonable for, a witness to take.
She's
Okay.
already been
So
here
I'll be
long
back
enough.
in a few weeks asking again, Your Honor.
Okay.
She's already
All
been
right,
here longer
um,
than some trials take. So what is long enough to know?
So I think there aren't any other short things. I'm happy to stay here another hour if y'all would like to. Nobody else wants to. This wasn't even a full day, y'all.
Recused
I
Judge
inquire-
Glanville says,
Yes.
Paige just
The
okay
item
everything the
that's
state wants.
I think the computer with the headphones on it, is that going to be in front of the jury? So that
No,
okay.
no, that's a ridiculous place for it to be right now. If we end up having to use it at all, and I appreciate the state, bringing it as a potential fail-safe. I don't know I think we're going to try while you're doing your oral argument tomorrow morning, somebody is going to come in here and see whether they can even have this be the backup. But it would, as I understand it, we wouldn't be using the video. We would just be using it for its audio output.
So it would.
And it would be up against the wall.
Up against the wall,
Yeah.
right. That's where we had it
Like we don't
initially.
even need the video part, right?
Not necessarily, but it would be showing the Zoom. It would just all be the same
Right.
thing that's
But
on every
the
other
jury
screen.
doesn't need to watch that screen. They can watch the screen they already have available. So
Right.
we can slide that entirely up against this back wall
That is where we
where it's
had it.
out of the way and not, blocking anybody's view.
That's
But-
exactly the way.
But we
had
would
it.
potentially use it for sound if our sound system continues to go on the fritz. IT tells me they think they have come up with a solution. I don't know whether they have or not. I also don't know how long it's going to take them to implement said solution. So I have asked them to have something else ready. This may be part of it, but yeah, okay. I'm reading an email that just got sent to me by the head of IT about it. Anyway, we'll try to get all of that addressed. Okay, so we will convene Sergeant Ingram on the scheduling. I had said 12. Is that doable, or is 12:30 just a better? Okay. So let's all plan to convene at 12:30 tomorrow. So when y'all show up at 12:30, it'll actually be the right time. And we'll see you then. Be ready to work on and have objections and responses ready for what we've just talked about. Okay, that's all I wanted to know. All right, so we're adjourned for the day.
Okay, so 12:30 p.m. Eastern tomorrow. I do, as much as we laughed about it, I wonder if they were really doing their video training this morning, the prosecutors. Like, that's one option. And thank you, Recused Judge Glanville, for the super chat, by the way. I really wonder if that's what they were doing this morning, because it was all of them that were gone, and they weren't even setting up their desk until 12:15. So, like, who still knows what happens? Because Whitaker didn't say anything to really address it. Even though she asked, didn't she ask where Mr. Steele was this morning? Like, come on. You're very quick to ask when, and it's important, right? You shouldn't start proceedings if a defendant's not present or if there isn't a single counsel present for one of the parties. But sometimes, like, if Adams is still seated there and Jeffrey Williams is seated there, it might not matter if Steele's not there. Like, just get started. But she asked anyway, so who knows what that was all about, and now it's just a giggle that at 12:30, so everyone can be here on time. So who knows? Who knows? Who knows? And yeah, so I think the IT email, it's like an end of the day thing, but you would think that even if IT wasn't working Saturday and Sunday, right, courts closed, what were they doing this morning? Was there IT issues in other places in the courthouse? Like, who knows? And then I have a question for you guys. If you guys want more YSL content, do me a favor and subscribe to Taybiz. Taybiz is very, very close to hitting 1K subscribers. Great insight in the chat. Taybiz is a mod on this channel too, so appreciate that, but just also great creator, very easy to listen to, easy voice, good microphone, and great content. So if you guys could do me a favor, if we could get him to 1K before the stream ends, that would be amazing. And then for tomorrow, I mean, we had some issues deferred. The state has to respond to Doug Weinstein's motion, so that'll be a time. Still seems a little unclear about that second set of 30 witnesses. And then even though we cleaned up some stuff with evidence that's supposed to come in under Sledge. I don't know. What if Sledge just gets up there and pleads the fifth, and then they become another long witness right after we hear the state say, "Oh, we don't have another witness. It's going to take so long." Like, what are we looking at? But other than that, I checked. I didn't see any new filings come in. I did say we were going to look over. Thugger Daily with the quickness had reposted this segment of this video footage. So let me get it back to the beginning. The alleged Percocet handoff. So what do you guys see? Yeah, so a couple loops there. And this is like, to me, it's one of those things where how reliable is video, right? Video can be evidence, but two different people can interpret and see things totally different ways. And then thank you so much, Tay-Biz. You guys, you're at 1K subscribers. So thank you so much for going over there and hitting that subscribe button. It'll be totally worth it because the content is great. So you're not just giving a like away for nothing. You'll get something in return. But totally, totally appreciate that. Congratulations to Tay-Biz TV. I'm seeing it's doing the 1.01K now. So you're getting the decimals. So super, super congratulations. And that's Munktunk. Antonio Sledge is Munktunk. But yeah, so you guys in the chat are seeing a handshake. I saw someone say under the table. It kind of went away. Looks like a VCR. Yeah, positive masculinity said under the table. And then, you know, the fact that two deputies go over there. Yeah, someone else was arrested for cigarettes trying to get in the courthouse, but this guy was able to walk in with a bundle of drugs. So yeah, that's what we were talking about a little bit today. And that was really, you know, some of the issues for these videos, the stuff with Lil Rod. That was really one moment where the judge actually was like, no, state, we're not just going to let all this stuff in. We'll let in a lot of these other like smaller accusations or evidence that goes towards intrinsic acts. But these things that are happening in jail or jail now currently beyond this indictment, I don't really know about that. So, and yeah, congratulations again, Tay-Viz. You totally, totally deserve it. Shout out to all the mods. They're all great people. I love them all. And we had a guest mod in here. We had Peter Ortiz in here from Professor Nez's channel. So that was cool. It's like a mod party today. Yeah, handshaking immediately to the cop. The guard knew what was going to happen. They thought his hand went under the table. I think the deputy was following him because he was approaching Thug, right? Yeah, you're just moving around the courtroom beyond any of the tables that you would normally be at. So, you know, I'm gonna make sure nothing crazy happens, which is really their job, right? You know, what was that judge that got jumped when the defendant jumped over the bench? Like, deputies, you gotta be ready for stuff like that. You never know. It looks weird. As his right hand went under the table, the cop was right there. And then, yeah, so then there's the attorney said that young thug, Jeffrey Williams, was clueless, had no idea what was going on or what was happening. Clearly a setup. Looks kind of staged. Okay, that was a Vegas story, Las Vegas story. Yeah, he's a bozo for even trying that. And I think, like, this looks different because it's a totally different setup in the room. So, you know, we're not really used to that because in the current courtroom, the defendants are all on one side. We're used to seeing them sit in the same place, but it is, whoever pointed that out, like, hey, maybe the deputy was just following along because somebody was walking up to where Young Thug is sitting, where Jeffrey Williams is sitting. It is like he is sitting more separated in this moment in time, so that is really unusual for there to be movement over there. Yeah, and then the deputies are the ones that bring the contraband in, allegedly. Yeah, we can replay it, sorry. Let me move myself. And we're looking at Jeffrey Williams get the handoff, like right about here is what we're looking at. Look at the hands. So there you go. There you go. And then other than that, you guys, I think we are all caught up. We are all caught up. So today has been, and we read that motion earlier today in a different stream, so it feels like we've been here since the morning, but it really technically was a half day. It was nice and productive. I'm going to start a little bit later than 12:30 tomorrow, and we're just going to be able to skip through some of the recesses instead of having some of the dead space in between everything. So keep an eye out for that. I'll put the thumbnail up. You guys can see that and hit the notify button if you want to get notified at the time it's going to actually go live. And I think it'll be a little bit cleaner rather than today we started and we had a recess right away. So, you know, I'm working on my time management a little bit more than this court is. And then, yeah, the pass was not under the table. It would have been like, oh, I'm covered. It would have been like right over like the clavicle. And yeah, a lot of people are recognizing that Thug looked surprised, like the facial expression, even though it's blurry, looks like a surprise. And then good to see you, Paralegal Institute. So look in the back and we see the deputy point. Oh, yeah, he's signaling to the other guy right there. So look right here, as soon as in the back when he stands up, look at him. Pointing him out that he's going up here to whoever's standing over here. So that is interesting. And then good eye, Paralegal Institute. You guys probably already know Paralegal Institute. But in case you don't, you can head over there and continue to binge watch some content. But yeah, let's wrap this up. We will... Anyone doing lives right now? You guys want to shout out real quick? Final chance? I don't know if you guys are following the Robert Tellis trial in Vegas. I don't even know. I don't know any background there, but Recovery Addict is covering it. So if you guys are following that case, that's live right now. AV is live still. I might go hang out over there. AV is still live talking about today's hearing. And I don't really see anybody else live. That's all my feed is giving me when I go under my subscription. So there we go. There we go. See you guys somewhere in the future. I'll be lurking and working for the rest of the day. See you guys tomorrow. You guys all have a good one. Take care.